Ken.
Great, welcome back everyone. We're ready to start our second session, the current state of research securing employment after incarceration. And we have Stacey Villalobos, who will serve as the moderator for this session. Stacey is a staff attorney at Legal Aid at Work, where she works on issues of racial economic justice. She represents workers fighting race discrimination before federal and state courts, as well as administrative agencies. Stacey also spearheads Legal Aid at Work's Ban the Box and Fair Chance work, representing job seekers with criminal records. Stacey is a graduate of Stanford Law School and Stanford University, and is the first in her family to obtain a high school diploma. Stacey previously clerked for the Honorable Fernando Holguin, District Judge of U.S. District Court for the Central District of California. She has been advocating for workers' rights for over a decade, beginning during her undergraduate years as an organizer with low-wage immigrant workers on campus. And she and her colleagues, Stacey and Chris, have been incredibly helpful with regard to the preparation of this particular hearing. So Stacey, go right ahead. Thank you.
Thanks so much, Councilmember Sandoval. So I'll start with introductions. Welcome everyone to our second panel of the day. I'm very excited to be moderating our panel entitled Employment After Incarceration. The current state of research securing employment after incarceration. And we're joined today by our experts, Professor Sujia, and hopefully our other expert, Professor Kurlichek, will join us in a second. So I'll start by introducing Professor Sujia. Professor Sujia is an associate professor of criminology, law, and society, and by courtesy, sociology at the University of California, Irvine. Her research examines the consequences of incarceration and other forms of criminal justice contact for individuals and their families, including how the criminal justice system influences participation in the labor force and political system. Her work has been supported by a variety of funders, including the Department of Labor, National Institutes of Health, and National Institute of Justice. Professor Sujia earned a PhD in sociology and social policy, as well as a specialization in demography from Princeton University. Professor Kurlichek, who I see now has joined us, is a professor of sociology, criminology, and public policy at Pennsylvania State University. Her research interests include juvenile justice and delinquency, rehabilitation, prisoner reentry, courts, and sentencing. Before joining Penn State, Professor Kurlichek was an associate professor of criminal justice at the State University of New York, Albany. Professor Kurlichek holds a PhD in crime, law, and justice from Penn State and an MS in administration justice from Shippensburg University. She has worked as a research analyst for the Pennsylvania Commission on Sentencing, the National Center for Juvenile Justice, and the Pennsylvania State Senate, and retains a major focus on public policy and evaluation research. So thank you both so much for being here today. We're going to go ahead and just jump right in. Professor Kurlichek, my first set of questions is to you. So what does the research tell us about how valuable background check information is for employers? And what does it actually tell employers about what kind of employee the applicant will be? And it sounds like you're still on mute.
Can you hear me now?
Yes.
Okay. I think the problem is that it's one of these things like the science is there, so should you do it just because you can, right? So the information started to become available, and all these employers that never did criminal background checks before were just expected to do them and started to do them because the information is available on the internet. And before the 90s, it was the FBI, the police. If you're going to be a teacher, we're going to check to make sure you don't have a child sex assault. There were some major things people would look at, but it wasn't that every little thing on your criminal record was explored by every employer. And then because with the internet, these records became so easily accessible, employers started looking at them, and they end up with this huge pile of information in their lap and no standards and no training on what to do with them. So if I have 30 applicants for the same job and 5 of them have a criminal record, it's easy for me to throw those 5 applications out. I don't have to screen any further. And that does a disservice to the individual looking for work. And it does a disservice to the employer because they're throwing out potentially good employees that they don't know how to consider. So I'm not sure, like Stacey, so you said, so what information does the employer get from these records? I'm not sure they really get much, and that what they get, I'm not sure they know what to do with it. The EEOC guidelines have attempted to help employers with this by setting out regulations about you shouldn't consider arrests that didn't lead to convictions, only convictions, right? And you should show a business necessity. Well, the problem is this is vague too. What's a business necessity? And this is problematic to me for two reasons. One, working with juvenile delinquents in a population of young offenders, we know that they're not necessarily specialists. Just because you shoplifted last week doesn't mean you're a lifelong property offender, right? Just because you're 21 in college and you get drunk at a bar and get a disorderly conduct or get in a fight and get charged with a simple assault doesn't mean you're a violent person for life. So these instances that happen don't define the person. And I think it's easy for employers to say, oh, you got arrested, you got convicted, you're of bad moral character. You're different than the rest of us. And as all of you know, I don't know, I went to college. I may have underage drank at some point at a Penn State game. I don't know. Most teenagers and young people take on behaviors at one point or time that could bring them to the attention of law enforcement. So the mark of a criminal record, which is what Diva Pager called it in her research, the question is, how does this affect you in the future? And what's important for employers to consider? Well, it's important for the employer to consider that if you did one or two minor things or even major things as a youth, that does not define you for the rest of your life. But in our current system, it tends to. Very, very few employers, very few states, very few criminal justice systems put a deadline on when that criminal record ceases to matter. And the other thing is that we find the research that's starting to emerge on individuals with criminal records shows that they can actually be some of the most loyal and dedicated employees because they've had such a hard time making it in life that when they get that opportunity, they're very grateful for it. So it's kind of a disservice to the employer to not consider these people. Just because they don't know what to do with the criminal record.
Now, you mentioned the deadline on when criminal records cease to matter, and you've published several papers, that look at the predictive value of really old criminal records, and the issue of the look back period, right, even came up in our earlier panel. Could you share your findings around those old records with us?
Yeah, so this came up to me as an early in my career as an assistant professor. A gentleman had asked a question of us, and I think he worked with NELP, Maurice Emerson, and he said, when is an old criminal record no longer predictive of someone's future behavior? And we kind of looked at each other and we're like, we don't know, but maybe we can figure that out. And so we found a couple data sets with which to explore that, which were what you would call cohort studies. You would take a group of, for what weeks was everybody born in Philadelphia in a certain year, everybody born in Racine, Wisconsin in a certain year. So you're not just studying criminals. Usually criminologists, we only study criminals. So we can't compare them that much to non-criminals. So these cohort studies gave us this ability to look at people that had contacts and arrests with the criminal justice system at a young age. And, crime usually peaks around 17, 18, 19. So people that have had some arrest or contact by that point and say, now let's compare them to people that didn't have any contact. And at what point in time does their risk of committing a new offense become statistically non-different from the people who didn't have an offense at a young age, an arrest or conviction? And our research in both the studies, our paths converged at about 7 years. And I don't know if any of you have looked at the recidivism research, but it's like this peak, the first 3 years, you're so much more likely to get rearrested. And then it declines, and it declines fast. And by 7 years out, your lines are just the same. And they're never zero, right? There's not a zero probability. I'm not going to go out and commit an offense later. I hope there's zero, but it's not zero. We all could do that. But I think for the employer's point of view, there's two things they're really concerned about here at seeing those paths converge. And one is these very rare, but very large negligent hiring lawsuits. So say, your Walmart, you hire someone, they had a disorderly conduct in their past. Now they're attending your dressing rooms and they make an inappropriate gesture to a young female and you get charged with negligent hiring because you should have known they were going to do that because they had this in their past. And I would just say, no, you shouldn't have, right? How long ago was it in their past? And a disorderly conduct is not related to this. So I think, but that's one of their concerns. And that's where I think we can have some policy that protects employers. And another very legitimate concern for employers is who's going to be a good employee. I don't want to take my time, especially if I'm a small business owner, training people who aren't going to show up because they're on drugs, who are going to quit in 2 months or be back in prison in a month. And that's a legitimate concern for the employer. And I think there's things that we can do, and this might come up later in our discussion. I think we're going to talk about appeals at some part today. There's things that people can do to show an employer that they're ready to change, they're trying to make a change. We call it signaling. What do they do to signal? And one of the big things people do actually to signal they're ready to make a change is search for a job and do very serious job searches. So I might be rambling a little bit here, so Stacy, you might bring me back in, but I think the fact that if someone has like a history, but it's behind them and you can see years and years of non-offending or not a pattern of offending, it was, this one event, this anomaly in their history, that it's safe for the employer to hire them. And if you're worried about what kind of employee they could be because of drugs or alcohol, there's drug testing you can do on the job. There's other things you can do to protect yourself than just automatically deny employment to someone that messed up at some point in their past.
And Professor Sujia, building off of that, what do we know about how employers make risk assessments when confronted with criminal history information? And what has your research found around that employer decision making?
Yeah, so thank you for having me, and I've really enjoyed this conversation so far. So employers, just like all people, there's sometimes a difference between what they say and what they actually do, especially when they're under all these time constraints and pressures and they're faced with complex decisions with limited information. In the case of hiring people with records, employers often say in surveys and in interviews that they need to know about applicants' prior offenses and behaviors to evaluate the applicant thoroughly, to minimize future risk of misconduct. So all the things that we've been talking about here and that were mentioned in the first panel. So in all these conversations, the focus is really on the offense type, the behavior that led to the offense, and it's really on that behavior. But we have done recent research that indicates that employers, just like everybody else, are also influenced by negative stereotypes and stigmas that are associated with the criminal justice system itself, that's apart from the applicant behavior, the specific behavior that led to the offense. So in other words, employers are averse to hiring people with records, not only because of these concerns about avoiding future misbehavior, but also because they are connecting criminal justice related stereotypes and stigmas to the applicant. These stereotypes are all consuming, as was mentioned in the first panel. We call this in sociology a master status. And in our findings, which are based on an experimental employer survey study, we found that employers, when they hear that an applicant has a record, whether it be an arrest that didn't lead to conviction or a conviction record, when they hear that, they start to associate a wide range of negative stereotypes that are really disconnected from the specific offense, the specific behavior. So for example, when they're evaluating someone with a record, they are more likely to think that that person isn't going to be a team player, or isn't going to work well with customers, or isn't going to respect authority, compared to an applicant that has the exact same behavior, but wasn't arrested and wasn't convicted. So, you know, I think that when stereotypes and stigma that are related to the criminal justice system come into play, it can make it really difficult for employers to make individualized assessments that are based on applicant conduct only, especially when they're under time and resource constraints. And this is really important to think about, you know, the stigmas and stereotypes. And I know it's kind of been mentioned earlier, but this is a big part of the decision-making process and a big part of the discussion. And I also want to add that, you know, there's a tendency for people to view records as neutral sources of information, as, you know, vetted and neutral sources of information about an applicant's past behavior. But we know from a large body of research and just from seeing the going-ons of what's, you know, been happening in our society these days, that criminal justice contact is also, the likelihood of that contact is also shaped by the type of neighborhood that a person grows up in, the color of their skin, how old they are, whether they're a man or a woman, how much money they have. And all of these factors are illegal to consider in hiring, but they are legitimated when they are seen through the filter of a record. So in these ways and in others, the record is really not a source of neutral information. It's influenced by these other factors that are related to larger systemic inequalities. And that's an important part of the discussion here.
Thank you so much for that, Professor Sujia. I think that might help explain some of the rubber stamping that we heard about anecdotally from the first panel. And now, Professor Krliček, you studied the formalization and implementation of fair chance hiring criteria by the New York Department of Health. And unlike prior research that had found non-compliance with the law and internal policy, much like what Professor Sujia was describing, what we heard in the first panel, the New York Department of Health was actually implementing their criteria, and you found that extra legal factors like race and gender did not actually influence their final hiring decisions. So can you share more about this research and its practical implications for employers who are looking to implement systems that will eliminate employer stigma and discrimination?
Yeah, before I do that, I just want to echo what Naomi just said, because a lot of my research has been into cumulative disadvantage. And it's just so important to realize that just one of the studies I was recently reading out of New York City, you know, there's self-report studies that show 56% of whites self-report using drugs, 49% of African Americans. So it's not that big a difference. 95% of the arrests were African Americans. And that doesn't mean we have police officers on the street going, oh, I'm going to just arrest this person because they're African American. It's where we put our police resources. We put them in the poor neighborhoods, we put them in certain areas where we know the crime is. So your likelihood of getting caught up with this in the system is not equal. I think that the research shows about by age 23, 33% of the population has some kind of criminal record, but for African American males, it's over 50%. So we're not talking about a small percent of our population. And in a capitalist economy, if you want to survive, you need a job. So these are important issues to me, and for a lot of the population. So what we were able to do in New York was actually quite unique, because most employers don't want you to look at what they're doing, right? They feel like you're coming in and judging them. Whenever you evaluate someone, I'm going to come in and judge you and tell you you're doing it wrong. But the Department of Health in New York was asked to take over vetting employees for all the nursing homes in the state and all the home health care agencies. So that's, you hire the nurse to come in and take care of your aging parent, right? Or a child with a disability. So these are very, you need to have trust in a person in these positions. And the state came up with certain criteria. They were very basic. And then the Department of Health went through a procedure where they had a team of 7 lawyers examining different offenses and determining what might be business related, not business related, who they could hire, who they couldn't hire. So on the front line, it's beyond ban the box. So you're I'm the person, I have a local Caring Hands, Angels Network, like my little home care health agency, and I'm hiring some people to come in and work. I meet you, I like you, I think you can do this job based on everything you presented. I give you a provisional hire. Now, when you get that provisional hire, you need to go and get fingerprinted at the state, and your fingerprints go to the Division of Criminal Justice Services, that we're also a partner in this research. And then they give your criminal history to the Department of Health. And this team of lawyers sits down, not knowing anything else about you. So they're not seeing your name, they're not seeing your face, they don't know your race, your gender, and they determine if you're eligible for hire. If they think you're not, you get a letter of, I think it's called pending denial, and you have 30 days to appeal that decision, or you're cleared for hire. But it takes that decision-making out of this informal setting where the employer could have implicit biases and things they're not even aware of affect their decision-making, and puts it in this formal process. So there were 2 or 3 interesting things that came out of the study that I want to highlight. And one is, if you apply for this position, or one of these positions, you have to, in your consent to the fingerprints and the criminal background check, you agree to a rat back, which follows you into the future. So we not only know what your criminal history was, we know what you did in the future, which makes this very interesting. And they did that for some reason, whether you got the job or not, whether you were ever denied the job or not. So we can compare past behavior to future behavior, and people who weren't hired to people who were hired. So it's a very, very unique study. And what the first thing we found was that formalizing this process and having this criteria set at this level really seemed to take a lot of the racial disparities out of it. And they seemed to follow what they said they were supposed to do. I don't know if any of you are social scientists here, but we found like 95 to 97% of the time, we could predict who they were going to hire if we just ran a regression, putting into it the variables they were supposed to be considering. And then if we put in race, gender, it didn't, like, go up by maybe 1%. It didn't really affect the decision making. That doesn't mean that the criminal record itself may not be racially biased, but there wasn't an added level of bias on top of it. The other thing we were able to do, because of this rat back process where they followed them forward, we were able to look and see, well, were the people they hired with criminal records any more risky than the people that hired without them? And that answer was no. And I think more importantly, they wanted to say, could we do this better? And I think their thought was, are there people we could screen out that we didn't? And our answer was like, wow, look at all these people you didn't hire that never had another arrest. They were excluded because there's lifetime bans on a violent offense or certain classes of offenses, but they weren't really risky. And you could have hired more people than you did. So to me, those are things that other studies just haven't been able to look at, because we only look at criminals, and 2, we only look at who's hired. So this was a very unique opportunity to compare risk levels and really dig deep with the employer about their process. And I think the policy takeaway would be these formal processes can work. They can reduce bias, and having specially trained people to do this versus just, if there's a way to vet this out. I spoke, I think, with Naomi about this the other day. I didn't have time to research it, but I saw these companies coming up in Baltimore and Chicago that do this vetting for small employers. If there's a way to have someone that knows what to do with that criminal justice history, then the information may be valuable to an employer. But the way it's being used now, I don't think it is. And then finally, I just think having the state do it instead of the little local small employer takes some of that liability off of them. So you hire someone with no criminal record and they go and abuse one of your employees and one of your clients. That's seen differently than someone that had any kind of criminal record, whether it was related or not. So it's getting that liability off the shoulders of the small employer, I think can be a big incentive.
Great. So Professor Sujia, here in California, the city of Richmond passed a local law that, similar to the model Professor Kurlichek was describing, actually takes criminal history information and the attendant liability that sometimes comes with it out of the hands of employer. So the law prohibits certain city contractors from making any inquiry into an applicant's conviction history, period. Not just before a conditional offer like the Fair Chance Act does, just period, with exceptions for certain sensitive positions. Are there any other models that you're aware of that similarly avoid or change the dynamic of asking employers to make decisions about records?
Yeah, and I think that this, in general, this area is really promising. You know, how can we take the burden off of the shoulders of the employer who isn't trained to go through these records and to understand what all of this means? So in terms of other models, you know, I have heard of certain background check companies trying to be smarter and more targeted in their screenings. Although in all honesty, I'm not sure if these practices are currently implemented or if they're more aspirational. But what has been proposed is these companies determine a priori with the employer what types of records are relevant for that specific job position. So this is exactly in the spirit of fair chance law. And then when they do the background screenings for those positions, the background check company presents them with information that is the relevant information that they determined is the information they would need to consider and to see. But the background check company does not show all of the other information that is not relevant. So maybe an arrest that didn't lead to a conviction, which we know entails or brings about the same sort of stereotypes. Even though that arrest didn't lead to a conviction, and even though the employer is not allowed to really consider that under California's fair chance law. So if we think that these sort of unconscious biases and stereotypes are really driving decision-making, then perhaps this is one way, you know, to filter out the things that are relevant versus are not relevant. This is one way to limit that sort of extraneous information. I also want to just mention here that the US is exceptional in many ways in terms of our criminal justice system, as we all know. But in this case, in terms of how we treat criminal records in the hiring process, we are also exceptional, especially in relationship to European countries. So these other places do not put these complex decisions about criminal record evaluations in the hands of employers. In most countries, criminal records are treated as private information, as confidential information. It's accessible to the police and the courts, but not to the general public. So not to the employers, not to the prospective romantic partner who is Googling you and finds your mugshot on the internet. You know, and we are the only country that makes our arrest records open. So arrests that don't lead to convictions. In other countries, employers are just not put into the position of needing to consider and to evaluate criminal background information at all.
Thanks. So shifting gears, as we heard earlier, the Fair Chance Act provides an internal appeals process wherein a job seeker can respond to an employer who wants to revoke a job offer. Professor Kurlichek, what's the importance of the appeal process?
So this is more, I think, some of this is research and some of this is anecdotal from my experiences. This is really important for the people that are trying to signal they've made a change in their life. You don't want to be, as I said, judged by that one thing you did in the past or that one piece of paper. Maybe you've gone through drug treatment. You can prove you've been clean for 3 years. You've held other jobs. You have letters of reference from your minister and other people that you want the employer to see you as a person and not as one mistake. So I think that the appeals process is very important. And the way I understand your act in California right now, it's you get like 24 hours to appeal, and it's more like appealing the accuracy of the record. And that's important too, because a lot of times these CRAs, they go out to the courthouses and they collect information, something sealed or expunged later, or something shows up that shouldn't, it's like telling the jury not to hear something. You can't tell the employer to unsee once they've seen it. But it is important for the individual to be able to say, this isn't accurate, I didn't do this, this is wrong. And it's also important for them to say, yes, I did this, but look how I've changed, right? And these are narratives when you work with individuals going through this process. They want someone to hear their narrative. I'm gonna I pulled a couple off of, you guys are in California, so you probably know Dave's Killer Bread, one of my favorite second chance employers. And they have on their website some quotes from some of their employees. Let's see if I can pull them up here. I had them up earlier. Hopefully they're still here. So like one of the quotes that I liked said, if I hadn't gotten the job at Dave's Killer Bread, I probably wouldn't have made it. The people that I work with, they're recovering like me. We're helping each other, encouraging each other. We're capable and tall. Because of this job, I'm alive. That's pretty profound. Another one said, Dave's has been the only thing there for me. I guess they saw something in me others didn't. I came here with nothing and nobody. I had to restart my life. I had a lot of personal things unraveling around me. This has been the only thing. And then this one I like too. And this, I guess this gets to heart it for me. It says, this woman said, employment doors are huge for people. I mean, you can work on yourself. You can work on your relationships, hence these, therapies and rehabilitation should go through. You can make amends. You can do all the work in the world you want on yourself. But if you can't survive, you're eventually going to do what you have to do to survive. And to me, that means going back to illegal earnings, because how else are you going to survive if no one's giving you a chance to prove yourself? Yeah. And to show that you're a good employee. And I think a lot of these companies, Johns Hopkins in Baltimore also has all these anecdotes of employees they've given a second chance to, who turn out to be some of the most loyal and dedicated employees they've ever had. So I think the discussion, I think we've already moved beyond, should you employ someone with a criminal record or not? The discussion has to come to who's safe to hire, who's not safe to hire, and employers have a legitimate voice there. But also, how do we make it safer for employers to offer these opportunities if they want to?
Yeah.
So
thank you for that. Those are incredibly powerful quotes. And I think my last question for Professor Sujia is, how can policies actually better support applicants with records, given the severe stigma that they encounter, and we know the huge impact that employment can have on folks? And what does your research show about how individuals with records actually go about their job search?
Yeah, so as we heard earlier, job applicants with records are very aware of this severe stigma that they are encountering. It's an incredibly frustrating, time-consuming process. And in my own research, so what I did is I used smartphones to collect daily information about how people were searching for work, and then looking at the types of employment that they found after release from prison. And the majority of people initially spent an enormous amount of time applying for jobs. And these are, online job applications, 45 minutes, an hour long. This is not just an easy, quick thing. They're going through personality tests, all sorts of things on these online job applications. And then when they get to that record, statement or question, they immediately receive a rejection. And so in this sort of experience, people in my study, the vast majority of them, even though they spent hours at the beginning on their job search, they were out of the labor market. They had quit their job search by the first month after release. And the fact that people are leaving job search after the first month, it's hard enough to get a job without a record, let alone trying to get a job with a record. And 1 month of job searching is just not enough. Other research has found that people get so desperate to get even a few days of paid work that they don't self-disclose their record, even though that is something that these reentry organizations are trying to train people about how to do and how to do, in a persuasive way. But they decide not to do that because it really, in many cases, doesn't get their foot in the door. So then they're working a few days on this probationary period. The employer ends up running a check. It's revealed that they have a record. And so not only now they have a record, but they were dishonest about it, right? And that looks very, very bad. But the reality is that people are in desperate situations. There are competing pressures, whether to self-disclose or not. And it's a complex calculation that applicants are making on their side as well. I think that in terms of the research on the job applicant side, one really important takeaway is that people with records will eventually get a job, but they need to stay searching for work. They need to stay in the labor market, and they will eventually find an employer who is willing to take a chance on them. Even in the studies that we have that show this really severe stigma, there are some employers that do hire people with records for whatever reason. And I think the fact that the majority of people drop out of job search within a month is a real problem. So the question is, how do we get people to keep that hope alive and to stay in job search to find a job? California's Fair Chance Law punts the background check till after the conditional offer to try to give that hope to people to keep them in job search. But the law allows employers to continue to list a background check statement on the job applications. So even if they're not asking, do you have a record, they can say, we are gonna check your record, or we plan to check your record. And recent research suggests that even a statement like this, it has nearly identical impacts on the job applicant as asking specifically, do you have a conviction? So there was a recent study out of the Ohio State University that found that when applicants see a statement like that, 3 out of 4 times they self-select themselves out of that job. They don't even bother applying for that job. And that there was no difference in terms of whether it was a background check statement, so just saying we are going to check your record, or if it was actually asking the question, do you have a conviction? So I think, from the applicant standpoint, there's not a lot of difference between a background check statement and then a question. Given this, I think one way to keep people in job search, to keep them applying for jobs, is to adopt San Francisco's ordinance language requiring that employers state affirmatively that they will consider applicants with arrest and conviction records. And if this sort of language was adopted on a statewide basis, and if we prohibited employers from being able to write a background check statement on the application, that might help encourage applicants to apply to more jobs and to stay in search for longer.
Thank you so much. And with that, we're now out of time. Thank you both so much for sharing your immense expertise with that. I'm going to hand it back to the council and Chair Mandelbaum for questions and public comment.
Thank you, Stacy, and thank you both for being here. And I know probably members of the public and certainly council members are chomping at the bits to tap your knowledge wells further on this. And I'll turn it over first to members of the council. Any of my colleagues have any questions that they want to ask to start us off? Well, Councilmember Sandoval.
Do we know of any efforts that have already been made to pass legislation that requires the affirmative language that you're stating? Professor Sujier or anyone else?
Yeah, I don't know of any, I am not the best person to answer this question, so Stacy, you should feel free to jump in. You know, I think that there's actually not research on the affirmative language as well, but because it is such a new thing, and not a lot of places have adopted affirmative language. So I think California would be a leader in that regard, you know, to take a stance like that following San Francisco.
Thank you.
I would just add to that that San Francisco and a few other local ordinances have those affirmative statement requirements. So for instance, Los Angeles does. So we do have sort of examples or models to look at the local level, but that I'm aware of no statewide requirement has been passed.
Thank you, Stacey.
In LA, is that for just government jobs, or does it apply to private employers?
No, that applies to private employers as well.
Thank you.
So, Professor Sujia, if I could turn to you for a moment, there's also been a subset of literature termed statistical discrimination that that casts doubt in the eyes of the authors on the efficacy of things like ban the box type policies, and the rationale being that they basically say that if an employer has limited information on criminal records, then they'll use easily identifiable traits like race or gender or age to make generalizations about someone's potential criminal history, since they don't have the specific access to that history itself. What's the current state of research on that topic, statistical discrimination?
Yeah, thanks for the question. You know, I think in academic and some policy circles, the biggest debates concern statistical discrimination and whether ban the box and fair chance laws are the right vehicle for trying to address race and ethnic inequalities in hiring. And at this point, we have a number of different studies that use different types of methods. Some are very robust, some are experimental studies. So what we consider kind of the gold standard in social science research. And I would say that the research does find that some employers are engaging in statistical discrimination. They're turning to these proxies to try to make educated guesses about who does and doesn't have a record. And many of these studies find that, for instance, young, Black, low-skilled men have lower employment rates after ban the box than before. But these studies also find that people with criminal records have higher rates of employment. So I think that while there is this evidence that ban the box can lead to statistical discrimination, there is also evidence that people with records are getting employed at higher rates than before, which is exactly the intent of ban the box and fair chance laws. But I think that, you know, at their core, sort of these discussions about statistical discrimination really comes down to the overwhelming evidence that racial discrimination in hiring is ever present, it is severe, and it gets perpetuated under various guises, including criminal record screening. So Megan referenced Diva Pager's study. Diva Pager's study was one of the most prominent studies on employer discrimination, where she sent out job applicants to apply for jobs, and she randomly assigned who would have the record. And her study found that, you know, criminal records do deeply penalize job applicants, which is not surprising, especially everything we've been discussing here. But she also documented that employers were much more willing to call back a white applicant with a record compared to a Black applicant with no record. And this was incredibly surprising because it just showed how deep racial discrimination continues to be in our society. So, you know, personally, I think when it comes to statistical discrimination debates, I think that the evidence really calls for more robust race discrimination enforcement and hiring, as opposed to necessarily backtracking on our ban the box and fair chance laws, which we have seen do improve hiring outcomes among people with records.
Thank you. I want to turn to public comment. Are there any other council member comments? Seeing no raised hands, I think we can jump into our public comments. So as a reminder, for those wishing to make public comments or ask questions, you can use the Zoom raise hand feature, and I know we already have at least one of those. You can also utilize the chat function or our email address, fehcouncil@dfeh.ca.gov. So I'll turn it over to our meeting administrator. I believe that's still Deputy Director Romero, and to start with the public comment.
There is one raised hand from Rachel Hoerger, and I'm now unmuting you.
Hi, I apologize. This is Rachel Herger from Bay Area Legal Aid, and my question was actually for the previous panel, but it just had to do with whether the Fair Chance Act, to what extent it protected existing employees rather than simply job applicants, as well as people applying for something like an internship or some sort of relationship that might not necessarily be considered formal employment. So I understand if the current panelists don't necessarily want to answer that question. It was just, it was a lingering one from the previous panel. Thank you.
Well, so one thing I will say on those regards, while the Fair Chance Act itself is focused on the application process, the FEHC regs, our council's regulations, address this issue in another context, and that's the disparate impact context. And so certainly using that type of information for other employment decisions like promotions or continued employment, where not justified by business necessity, it can be unlawful as well under the Act. So while it may not be specifically within the Fair Chance Act, I'd encourage folks to look at our regulations and which apply throughout the life of the employment relationship, including promotions and other employment decisions.
Thank you.
There are no other raised hands, so I will read some of the chats. From Joshua Kim, is either panelist aware of any research comparable to redemption period research by Bushway, Nakamura, or Blumstein that correlates risks of recidivism to one or more objective factor?
So the research that I was talking about earlier that I did with my colleagues Brame and Bushway, we basically look generally at that time to recidivism and time to which you're no longer at risk. And then Blumstein and Nakamura replicated that in New York State using a cohort of arrestees in New York. And they divided it up a little more by like, did you have a prior record or not, a specific type of offense or not. And I believe, if I'm remembering correctly, they came up with similar time periods to us, about the 7 years for more serious offenders. And then for minor property offenders, their time was about 4 years. Now, the problem is, going back to what Naomi was saying, people give up a job search in a month. 4 years is a long time to live without a job, right? It's a long time to get rejected. So I think where the research needs to go and where we're trying to take it is how can we determine who's safe to hire sooner? And this gets back to two things I was talking about. And one is the fact that what tells us if someone's risky is kind of their patterns of behavior. So it's not just one event, because anybody can mess up. But if you see someone that's had 2, 3, 4 contacts, arrests, convictions coming up in the past couple of years, they may still be involved, right, in that risky lifestyle, that drug lifestyle. They're not. It's like putting someone in AA when they're not ready to admit they're an alcoholic. They're not ready to change. So they're probably not your best employee. But if you find somebody who's maybe gone through drug treatment while they were in placement, they came out, they have these letters of recommendation, they're putting it all out there to get a job, they're sending a signal. It's called signaling research. It's also Bushway and Apel. What is the signal that I've changed? Which leads to my second point, which was the importance of this appeal process, which I'm hoping that more people will consider putting into their laws and into their regulations, where you give people a reasonable amount of time to actually make an appeal to a judgment and show what they've done to change themselves. And certain states, I'm not an expert on California law, but I know, so I worked in New York, we had a certificate of rehabilitation you could get. Connecticut has a certificate of employability you can get, something that you can give to an employer that says, look, I had to do all this to get this to show I've changed. So it's showing somebody that you've turned that corner without it being, say, I still think there should be a limit to when a criminal record should be able to be considered. It shouldn't haunt you the rest of your life. But I think within that time period, employers need more guidance, and the individual with the criminal record needs some way to show the employer where they are in their journey. I don't know if that helps or not.
Can I chime in here about this signaling research as well? Because this is an area where I think there's a lot of research continuing to come out, and it's an area of debate to see how valuable, how beneficial a positive signal can be to overcome this sort of really severe stigma, right, of the criminal record. And I think from what I've seen, my reading of this research is that it's really a mixed bag, because sometimes these certificates and the proof of rehabilitation provides a bigger, harsher signal that this person has a criminal record, and puts more attention to the fact that they have a record in a way that ultimately doesn't help the person in the end, whether they get a job or not. So I think there is promise here, and I think that this is one avenue. But I also think we really can't forget that there are these such severe stereotypes to the criminal justice system, where some of these things really just can't overcome the sort of really severe stigmas that are attached to the criminal justice system.
Does anyone have any thoughts on how to take some of the discretion out of the appeal process? Because I think that's where issues about bias come into play. And this discussion reminds me somewhat of what were the points of contention in Prop 25 in California over bail versus money bail versus having algorithms and having the discretion be with the judge in determining who could be released pending their case. So I'm wondering if there's anything that any of you have seen that could be used concretely to reduce the discretion that lies with the employer in California, and what is after in the post-offer process.
I think that's something that Naomi and I both touched on when we talked about these vetting processes that are removed from the actual employer to some extent, or provide them with some assistance on how to use the information they're getting. Right, so we do this all the time within the criminal justice system. We do risk predictions to determine who gets parole or this or that, but you can't, I think there's two problems. One is it's risk prediction, right? So we're working on probabilities. And none of these models, if you can use the most advanced algorithm you can come up with, and you probably predict correctly 90% of the time, say you even predict correctly 98% of the time, that one person that gets hired that then messes up is going to be, it's now going to be Megan's law. You're going to make a law based on that one person. And that's why I come up to not just removing this vetting responsibility from the employer, but having some kind of protection where we realize we're never going to perfectly predict what somebody's going to do in their future, whether they have a criminal record or not. But time after time after time, study after study after study, as much as we don't want to admit it, It shows these algorithms, these statistical models do better than an individual's gut. Right? People want to go, no, I'm going with my gut. I know that person's dangerous. And study after study after study shows these models are the way to go. But it's just going to take that one person to mess up that you predicted. 90% of your people, 95% of your people you said were going to be safe or safe. That one person messes up, if that makes the news, what's that going to do to that employer?
Well, and the algorithms were one of the reasons that Prop 25 didn't pass. People didn't trust that either. So.
People want to trust their gut. They don't believe something else could do better than they do. So I don't know how you get past that, except that just to keep showing the research.
Let me invite Director Kish now to address a question that we weren't able to address because of tech issues before from the earlier panel on the type of evidence that the department looks for to support a Fair Chance Act claim.
Thank you. Can you all hear me now? First, before I jump into the specific question, I just want to thank the panelists, both in our first session and here, and especially this last discussion has, I think, pulled back the lens a little bit about what we're talking about. Because what we're talking about essentially is a society-wide issue, right? We incarcerate more people per capita and in absolute numbers than anybody else. We make those records available to private entities, to employers, and to third-party screening companies. And what the ban the box law in California and in other jurisdictions is attempting to do is provide some guidance on what the heck are we going to do with the outcomes of those social choices to incarcerate this many people, knowing particularly the disparities, racial and otherwise, that run throughout the criminal justice system, which is why the law is enforced by the Department of Fair Employment and Housing, right? The state anti-discrimination agency, and not another one. I think many of the problems that we're identifying have to do with things like, we know there are certain types of claims that few people bring in anti-discrimination law. One of them is a failure to hire claim. People don't know why they aren't hired. Already taking out the issue of criminal history, that's a problem. Adding in the type of penalization that criminal history brings to a job applicant makes it that much less likely, I think, that individuals can afford to take the time to file an individual complaint. And so I think we've identified both in this panel and in the last a couple of really specific and promising interventions. In my view, all of these interventions are Band-Aids. And what we actually need to have is cultural change so that the people making these decisions, the employers, people who go into HR, people who are running staffing companies, lawyers who are acting as in-house counsel and advising companies, all have kind of incorporated into their own worldview the research that we've been hearing about, which is that people are excluded and they're excluded unfairly. Until we get to that point, and by the way, I think that is what ties this to the broader social movement that we're going through in this country right now about racial justice and about identifying and critiquing disparities in our society. So I'm hopeful that this conversation contributes to that. It is certainly in conversation with this broader social movement, and it's going to be the broader social movement that gets us to a place where we aren't fiddling around the edges with a massive exclusion of job applicants from economic participation in the life of our society. So that's my soapbox. I will answer a specific question about the evidence. In a lot of the cases that we see at DFEH, we're looking at procedural violations, right? So we know that employers have to make a preliminary offer. They have to send out a letter. They have to do an individualized assessment. They have to send out another letter. The letter has to say certain things. And I just realized that I'm talking really fast for the closed captioner, so I apologize for that. So when we get a complaint, oftentimes it will be the employer didn't do something that they're required to do. And the approach there is, well, either they did it or they didn't, right? Meaning they can show us that they followed the steps that they were supposed to follow, or they didn't. Now, in those cases, often what we're trying to do, it's not just correct the process, it's also re-engage with the applicant to see if that person might have been offered the job, absent the procedural error. Where I think we face a more difficult evidentiary issue is in those cases where there is not a procedural violation, but it comes down to something that was identified in the first panel, which is the individualized assessment, right? So here is where the employer is supposed to think about, although the law does not require them to write it down, but they're supposed to think about what is the specific relationship, the direct relationship between the criminal history and the job, the actual duties of the job. And so that's a case-by-case analysis, and every case has to be treated on its own terms. I think that's really hard. I think it's really hard to ask government regulators to second guess employment decisions like that. We do it in some cases. In some cases, it's more clear than others. But that is the black hole in this process. And I would just echo something that one of our first panelists said, which is that we actually developed a form. It's on our website. The law does not require its use, but it is intended, it's 2 pages long. It's intended to help employers do just this. So it actually says, write down, what are the specific duties of the job? Write down, what is the criminal conduct? How long ago did it occur? How old was the applicant when it occurred? What job training have they had? What work experience? What other mitigating factors? And it requires the employer to kind of go through this process in plain language. My hope, we don't have data, my hope is that going through that process causes people to second guess their own biases. But we'll see, right? We don't actually know, in part because people don't have to use this form. But I do want to flag that it is available for free on our website, and I encourage folks to use it.
Kevin, can I ask you a question? In department's analysis, is the burden of proof on the employer to prove job relatedness, business necessity, whatever you want to call it?
Sorry, I was just going back to the statute, which I have up on my computer. Yes. The answer to the question is yes. The statute says an employer that intends to deny an applicant a position shall make an individualized assessment, and the conviction history has a direct and adverse relationship with the specific duties of the job. So the employer has to do that in order to deny the job. Then it's a question of whether that was adequate. And that's a difficult question, not just for a government regulator, but also for the courts.
So we've got 1 minute left before we break for our lunch. And so are there any additional questions or public comments that we can get through in the next minute or couple minutes? And then as a reminder, there will be a final public comment period at the conclusion of our afternoon session.
We do have one final raised hand from Dr. Noel Vest, and I'm allowing him to speak now.
Awesome, thank you so much. My name is Noel Vest. I'm a postdoctoral research fellow here at Stanford University. I'm curious, California just became the 5th state to ban the box in higher education, so on college applications. I'm curious, first of all, your opinion on the influence of these ban the box in higher education policies, and then if there's any research in the near future to kind of look at these policies.
So these are difficult things to study, and it's because you don't know the population of people who didn't apply before because the box was there. So you have, I don't have any ideas on this. I know that New York banned the box on their state colleges, and people have been starting to look at it, but it's really hard to get the right population to study. So I think it's like a methods problem that we are currently working on and trying to study, but I don't know of any really prominent research at the time.
I think there has been an audit study, but I don't know the results off the top of my head, but I think there was, and I don't know what the specific contextual factors were there. I think, so if you want to email me later on, I can point you to the resource set that I'm thinking about. I think I hold out more hope for banning the box in terms of higher education, because I think that where we get into a particularly dicey situations is the fact that there's just really, the employers are under such huge time and resource constraints and are really unable to take the time to fully think about all the different aspects of the applicant. And I hope that in evaluations for higher education admittance, there is a bit more time and resources to give to that decision, where people can think about these, unconscious biases that they have and give more thought to these things.
Well, thank you so much to both of our academics for a really enlightening discussion, and to Stacy for facilitating that. We're going to take our lunch break now and pick back up at 1 o'clock. So we hope you rejoin us at 1 o'clock for a series of very interesting testimony and remarks by a number of different perspectives, starting with Father Gregory Boyle of Homeboyle Industries. So you do not want to miss this afternoon session. And we look forward to seeing you back at 1 o'clock.
Welcome back, everyone, for our third and final session for the civil rights hearing, which is the current landscape, what's working, what's not working, and identifying unmet needs and opportunities for change. Our first expert panelist is Father Gregory Boyle, who is a founder of Homeboyle Industries in Los Angeles, the largest gang intervention, rehabilitation, and re-entry program in the world, a native Angelino and Jesuit priest from 1986 to 1992. Father Boyle served as pastor of Dolores Mission Church in Boyle Heights, then the poorest Catholic church in Los Angeles that also had the highest concentration of gang activity in the city. Father Boyle witnessed the devastating impact of gang violence on his community during the so-called Decade of Death that began in the late 1980s and peaked at 1,000 gang-related killings in 1992. In the face of law enforcement tactics and criminal justice policies of suppression and mass incarceration as a means to end gang violence, he and parish and community members adopted what was a radical approach at the time: treat gang members as human beings. In 1998, they started what would eventually become Homeboyle Industries, which employs and trains former gang members in a range of social enterprises, as well as provides critical services to thousands of men and women who walk through its doors every year seeking a better life. Father Boyle is the author of the 2010 New York Best-Time seller, Tattoos of the Heart, The Power of Boundless Compassion. His new book, Barking to the Choir, The Power of Radical Kinship, was published in 2017. He has received the California Peace Prize and been inducted in the California Hall of Fame. In 2014, President Obama named Father Boyle a champion of change. He received the University of Notre Dame's 2011 Letare Medal, the oldest honor given to American Catholics. Currently, he serves as a committee member of California Governor Gavin Newsom's Economic and Job Recovery Task Force as a response to COVID-19. Father Boyle, thank you for joining us.
Thank you all. It's good to be with you. And Gabriel, nobody ever pronounces Letare correctly, but you did. I always brace myself for it. So good job.
Father Boyle, I did research, as a Jesuit educated individual.
There you go. So you know your Latin.
Yes.
I had to be told how to pronounce it too. So anyway, so it's good to be with all of you. I'm, in my brief time I have with you, I'm an aerial view guy, so I'm higher in the clouds rather than what should we do next? But I leave that part to you. But we're all called to imagine the same kind of community which is to say a community of kinship such that God in fact might recognize it. We're all invited to somehow imagine a circle of compassion and then imagine nobody standing outside that circle. And to that end, what the hope is that we will together find ways to dismantle the barriers that exclude. And so we inch our way out to the margins. We stand there with the poor and the powerless and the voiceless, and we stand with those whose dignity has been denied and those whose burdens are more than they can bear. We're invited out to the proximity, to the vicinity of folks who are in fact easily despised and readily left out. We're all invited in our way, in our own particularity, to stand with the demonized so that the demonizing will stop, and to stand with the disposable so that the day will come when we stop throwing people away. But the high aerial view, for which you will fill in the blanks in the weeds, is no kinship, no peace, no kinship, no justice, no kinship, no equality. No matter how singularly focused we may well be on those worthy goals, the truth of the matter is they actually can't happen unless we have this undergirding sense, as Mother Teresa used to say, that we belong to each other. And the problem in the world, of course, is that we've forgotten. So we stand at the margins, and each one of you on this screen, you brace yourselves, because people will accuse you of wasting your time at the margins. But the prophet Jeremiah writes, "In this place of which you say it is a waste, there will be heard again the voice of mirth and the voice of gladness, the voices of those who sing." So we don't go to the margins to make a difference. You go to the margins so that the folks at the margins make us different. And so we try to obliterate the illusion that we are separate, that there is an us and a them. So I'll give you an example that just sort of happened. I just got a text from a homie named Sammy, and he had spent 18 months with us. It's an 18-month training program, which in many ways parallels the 18 months it takes to attach to a caregiver as an infant does. It's a time of repair and restoration. Sammy came to us from prison, had been locked up for 5 years, I think. A gang member, tattooed. He had extensive treatments to remove his tattoos. He came, like everybody who walks through our doors, barricaded behind a wall of shame and disgrace, and only tenderness can scale that wall. So if it's true enough that the traumatized are most likely to cause trauma, it's equally true that a cherished person will be able to find their way to the joy there is in cherishing themselves and others. Our goal is not surviving as the fittest, but thriving as the nurtured. And so Sammy experienced that at Homeboy for 18 months. And then we want the transition to be seamless from finishing 18 months with us to gainful employment beyond us. And so one of our 4 job developers in our workforce development office section of Homeboy found him a job at a Walmart warehouse. And oh my God, he was there for 2 weeks and happier than a clam. And they gave him his badge. And he just texted me that he had walked into work this morning and the badge didn't work. And next thing he knew, the security were escorting him out of the building, because once they had done some secondary scrutiny of his past, well, they escorted him out of the building and took his badge away. There's just not a way to be able to call that right, good, just, and true. But it's born of a principle that we have forgotten, that we belong to each other. And well, Sammy didn't know that his 5-year prison term was really sentenced to life without being able to get a job, or at least that's how he feels now. So I'm okay on the aerial view. I leave it to you to figure out, wow, how do we change that around? But except that unless we are utterly, absolutely convinced that we belong to each other and that all of us, including the CEO of Walmart and anybody underneath him, everybody is a whole lot more than the worst things they've ever done, including Sammy. And anyone would be proud to call Sammy one of your workers. And so, how do we get to this place where we can say no kinship, no peace, no kinship, no equality, no kinship, no justice? That the problem is, in fact, that we've forgotten that we belong to each other. And so it looks like LA County, I was reading today, that LA will probably hit 300 homicides at year's end. And mainly they are gang involved or homeless people who are victims. We haven't seen 300 since 2009. And of course, that doesn't compare to the high moment, which was 1992 when we had 1,000. But kinship looks like this. When we've forgotten that we belong to each other, those 300 homicides happen someplace else. But when we were utterly convinced that there is no us and them, there's just us, then those 300 homicides happened in our family. And the only way to get to that point is to somehow stand in awe at what the poor have to carry rather than in judgment at how they carry it. The principal suffering of the poor throughout history and throughout scripture, I might add, is shame and disgrace. And at Homeboy, we know that you have to kind of dismantle these messages of shame and disgrace. And you have to, in turn, hold the mirror up and tell people the truth of who they are. It's the same truth we all share, which is you're exactly what God had in mind when God made you. And so, like the Buddhists say, oh, nobly born, remember who you really are. The homies always say at Homeboy Industries that, you know, we're used to being watched. We're not used to being seen. And when you see people, there's a kind of a mystical, therapeutic mysticism, we call it at Homeboy, where you see the whole person and you don't get tripped up by behavior or by tattoos or by somebody's rap sheet. In the Acts of the Apostles, it has this one odd line and it says, and awe came upon everyone. And it will always be the measure of health in any community at all when we are able to stand in awe at what the poor have to carry rather than in judgment at how they carry it. So a number of years ago, I was invited to speak to 600 social workers in Richmond, Virginia. And it was one of those gang in services. It was, you know, they commandeer a hotel ballroom from 9 to 5 and all these social workers get credit for attending this 9 to 5 thing. And there are keynotes, there are workshops, there are breakout sessions. So I said yes, figuring, you know, I'd give a keynote, which is what I had done many times before at these things. So I bought my ticket. Well, a week before I was to fly out, I pull out the original invitation letter, and to my horror, I discover that I am to be the only speaker all damn day from 9 to 5. And I said to myself, what the homies always say, oh, hell no, I'm not gonna be the only speaker. And so I called 2 homies and trainees, Andre and Jose. They were like at midpoint in the 9th month or so of their 18 months, gang members. And I sit them down, and they're actually enemies. They were from rival neighborhoods. So I sat him down. I said, look, at the end of the week, you're flying with me to Richmond, Virginia. I'd like you to get up in front of 600 social workers and tell your stories. Take your time, because we got a long ass day to fill. So I had never heard their stories, and Jose gets up first, and he's like 25 years old at the time, I guess, and gang member, been to prison, tattooed. At that juncture, he had become quite the valuable member of the substance abuse team, a man solid in his recovery, and now he's helping younger homies and homegirls with their addiction issues. So not only had he been to prison, but he had a stretch of time as a homeless man, and an even longer stretch as a heroin addict. And so he gets up in front of 600 social workers and he says, I guess you could say my mom and me, we didn't get along so good. I think I was 6 when she looked at me and she said, why don't you just kill yourself? You're such a burden to me. Well, 600 social workers audibly gasped. And then he says, it sounds way worser in Spanish. And we got friggin' whiplash going from gasp to laugh. And then he continued, he said, I think I was 9 when my mom drove me down to the deepest part of Baja California. And she walked me up to an orphanage and she knocked on the door. And the guy came to the door and she said, I found this kid. And she left me there for 90 days until my grandmother could get out of her where she had dumped me. And my grandmother rescued me. My mom beat me every single day of my elementary school years with things you could imagine, and a lot of things you couldn't. Every day my back was bloodied and scarred. In fact, I had to wear 3 t-shirts to school each day. The first t-shirt, because the blood would seep through, and the second t-shirt, you could still see it. Finally, the third t-shirt, you couldn't see any blood. Kids at school, they'd make fun of me. Hey, fool, it's 100 degrees. Why are you wearing 3 t-shirts? And then he stopped speaking, so overwhelmed with emotion. And he seemed to be staring at a piece of his story that only he could see. And when he could return to speech, he said through his tears, I wore 3 t-shirts well into my adult years because I was ashamed of my wounds. I didn't want anybody to see them. But now I welcome my wounds. I run my fingers over my scars. My wounds are my friends. After all, how can I help heal the wounded if I don't welcome my own wounds? And awe came upon everyone. The measure of our compassion lies not in our service of those on the margins, but only in our willingness to see ourselves in kinship with each other. Because if we don't welcome our own wounds, we may well be tempted to despise the wounded. And we may give Sammy his last check at a Walmart warehouse. There is a Christmas carol, O Holy Night, and in it says, long lay the world in sin and error pining till he appeared and the soul felt its worth. and yet it's about Christmas, and yet it's about Jesus. But how is it not the job description of any human being who owns a pulse? You appear, and the soul feels its worth. O nobly born, remember who you really are. And we are all returned at the margins to our own mutual dignity and nobility. And not a single thing will change until that does. So there was a kid, we all called him Bandit, and he kind of was one, and he was a gang member, and he sold crack cocaine in the projects. And in my old days, I would ride my bike into Aliso Village or Pico Gardens, where we had 8 gangs at war with each other. I buried my first homie killed because of this sadness in 1988. I buried my 238th last week, a young man named James. So I remember one night I was in Aliso Village housing projects, and I saw this bola of gang members. So I was talking with them. I was straddling my beach cruiser, and I could see in the parking lot there was Bandit, and he was running up to a car selling crack. He comes back. He doesn't know that I've joined the group. He's counting his money. He wasn't all that embarrassed to see me there. He always refused to go to Homeboy until he didn't. And he walked in into the door one day, and he asked him milagro, and I couldn't believe he was there. And he said, I'm tired of being tired. So he began 18 months with us. They say if you don't transform your pain, you'll just keep inflicting it, transmitting it. And so that's kind of what he did. He excavated his wounds. He came to terms with what was done to him as a kid and what he did as well. And then he was ready to be sent out. And this time, the world, of course, would throw at him what it will, but this time he wasn't going to be toppled by it. And so as we do, we try to make the transition seamless. And he was sent to a warehouse where someone gave him a chance, where somebody knew he was a whole lot more than the worst thing he had ever done. So cut to 5 years later, he's el mero chingon of the whole damn warehouse. And then he's the supervisor another 3 years. And then a couple other years, he's even more highly promoted and buys a house and marries his sweetheart, childhood sweetheart, and has 3 kids. Well, I hadn't heard from him in a long time, and no news is good news with gang members. So he calls me on a Friday afternoon, kind of late. He's medio paniqueado in his voice, and he says, "Gee, you have to bless my daughter." I said, "¿Qué pasó, mijo? Is she sick? Is she in the hospital?" "Oh, no. Jessica, my oldest, she's 18. She's going to Humboldt College on Sunday." And that's far. And we're scared for her because she's a little chaparrita, you know, and I don't know, can you give her a blessing before she leaves? I go, "Oh my gosh, I'd be honored. Look, tomorrow's Saturday. I have baptisms at 1. Why don't you come by at 12:30? We'll do a little send-off." And so sure enough, Bandit and his wife and the 3 kids show up, including tiny little Jessica. So we stand in front of the altar, and I said, "Well, let's encircle her. Everybody kind of touch her. Put your hands on her shoulder. Go ahead. Put your hands on her head." And I say, you know, close your eyes, bow your heads. And as the homies say, I do a long ass prayer. You know, I go on. And somewhere in the middle of this thing, oh my God, we're all chillones, we're all sobbing. Every one of us. And I don't know why we're crying, except for the fact that Bandit and his wife don't know anyone who's ever gone to college, except me. Certainly nobody in their families. And so I finished the prayer, and we're all kind of wiping our eyes, and we kind of laughing at how mushy we got. And so to change the subject, I look at little Jessica. Hey, what are you going to study at Humboldt College? And she was very quick. Forensic psychology. I go, damn, forensic psychology. And then Bandit chimes in, yeah, she wants to study the criminal mind. Jessica looks at her father and does one of these, you know, and we all laugh. And he says, yeah, I'm going to be her first subject. So we walk out to the parking lot, and big abrazos, and they pile in the car, but Bandit hangs back. And I'm glad he has. And I said, oye, mijo, can I tell you something? I give you credit for the man you've chosen to become, for choosing to walk in your own footsteps. I'm proud of you. And his eyes fill up with tears, as do mine. And he says, ¿Sabes qué? I'm proud of myself. All my life, people called me a lowlife, a buena para nada, good for nothing. I guess I showed them. I said, yeah, I guess you did. And the soul feels its worth. Oh, nobly born, remember who you really are. Folks at the margins are used to being watched. They aren't used to being seen. And though I'm kind of have this aerial view, I leave it to you to figure out how to translate our own sense of belonging into policy, how to address unmet needs, and how to reimagine our social contract. But of this, I'm utterly convinced that if we go to the margins, they get erased. And no kinship, no peace. No kinship, no justice. No kinship, no equality. And so we, soon enough, cease to care if anyone accuses us of wasting our time at the margins. For in this place of which you say it is a waste, there will be heard again the voice of mirth and the voice of gladness, the voices of those who sing.
Thank you, Father Greg Boyle.
Thank you.
That wonderful blessing and focus on why it's important for us to establish kinship. And indeed, it was a great reminder of the role that each of us plays, not only on this commission focused on civil rights, but in the greater community. Thank you for joining us, Father Boyle.
Thank you all. God bless you guys.
God bless you, Father. Next, continuing our session, we will have Beth Avery, who is a senior staff attorney with the National Employment Law Project, a nonprofit organization that conducts research and advocates for equal access to quality jobs for all U.S. working people. Beth works to promote racial equity in employment with a focus on expanding opportunity and reducing employment barriers for people with arrest and conviction records. By way of example, Beth worked with a coalition of California advocates to enact the California Fair Chance Act in 2017 and has helped craft and pass other fair chance laws in numerous cities and states across the nation. Before joining up, Beth clerked in federal and state courts. She's a graduate of Harvard Law School. Beth?
I hope my audio is working. Please let me know if it's not, and if you can't hear me. I usually use headphones, but I'm not right now. Thank you for that lovely introduction, and thank you so much for the opportunity to speak to you all today about this important issue and for organizing this wonderful day-long briefing. So I do have I was told I wasn't going to be the only one with slides, but so I prepared some, but apparently I am. So, but I'm going to share them anyway because I'm a visual person, and that way you don't have to stare at my face, and I don't have to be self-conscious. So I'm going to go ahead and attempt to share my screen. Hopefully, I have permissions to do that. If not, I will do without. Okay. So Stacy, can you give me a nod if you can see my PowerPoint? All right, thank you. You're the person who's up on my screen. So great. So I'll start by just addressing some ways to potentially strengthen the California Fair Chance Act and to improve the enforcement of the laws that currently exist. The first panel today, I realize, covered this in depth, so I'll try not to be repetitive and I'll be brief. And I'll just note that this photo in the background is from one of the hearings to pass the law in front of the legislature, and that's a long line of supporters waiting to testify in support of the now law. So as you know, in addition to the statewide statute, both San Francisco and Los Angeles have ordinances, fair chance ordinances that predate the state law and that have been enhanced since then. So some of the low-hanging fruit for reform to enhance the state law would be to amend the state law to match stronger provisions in the local laws. Some of these have been mentioned earlier today. I'll just highlight a few. And so these ordinances have been in operation for the past several years. And so there's some low-hanging fruit. So first, the exceptions to the law. The California law includes an overly broad exception for any position for which a background check is required, which means that there are numerous exceptions. And unfortunately, this exception allows the stigma of a record to enter an employer's hiring calculation from the start. Whereas if it's revealed later in the hiring process, perhaps that person might be hired. So San Francisco has narrow exceptions. It only allows for partial exceptions where there is truly a conflict with state or federal law. So for example, where a law might require that the background check be done up front. In the least, even if some employers are allowed to ask about records earlier in the process, they should nevertheless be required to comply with the procedural safeguards in the law. So the notice requirement, opportunities for the applicant to respond. Those are all, unnecessary exceptions. And I'll say that even when a law requires a background check, just delaying the inquiries about records, doesn't impact public safety. Those background checks are still going to be done. It's just a question about when, and really about the balance between, an individual's right and interest in having a job to support themselves and, some marginal efficiency. So second, this was mentioned earlier, so I'll just quickly note that the ordinances require job site postings and language and job announcements. And that was touched on earlier, so I won't belabor that point, but I reiterate it. The California law doesn't include any express record keeping requirements. I realize that some may be required overall by DFEH, but the San Francisco and Los Angeles laws require employers to retain documents for 3 years that show that they did individualized assessments, et cetera. Relatedly, I believe it was mentioned earlier that a presumption that the employer did not adequately do an individualized assessment, if they don't have records showing that, would be one way to ensure that those individualized assessments are actually done. And so it becomes less of a he said, she said, show me the evidence. Finally, the California Fair Chance Act does not expand pre-existing legal limits on what records are off limits to employers. It just refers to other provisions that were already existing in law. Labor Code 432.7, I believe, is the provision. And so that includes, prohibiting employers from looking at arrests, diversion records, dismissed juvenile records. San Francisco, in addition, includes a look-back limit prohibiting employers from looking more than 7 years back. So that was mentioned earlier, and I would just reiterate that as well. Let's see if I can go to the next slide. Now for enforcement, and I should start by saying that the Department of Fair Employment and Housing is doing a great job, working with community organizations and using its resources, which are limited, and being very communicative and putting great resources on their website. So I first want to commend them for everything that Director Kish, Brandon Butler, who spoke earlier, everyone's doing a wonderful job. So these are suggestions for improvement. And some of them would require legislative changes, and some may be possible without legislation. Now, my understanding is that DFEH has received fewer complaints than anticipated, which, instead of demonstrating widespread compliance, likely indicates a lack of awareness of the law and perhaps difficulty in reporting violations. So the first suggestion here is that enforcement mechanisms be expanded to allow for the imposition of monetary penalties by the Department of Fair Employment and Housing. This would be in addition to the ability to seek damages in court, which can be difficult for individuals to do, requiring a lawyer going to court. And it can be difficult for even DFEH to do if they decide to take a case. Moreover, appropriate damages for a hiring process violation can be difficult to estimate. And having the ability to impose monetary penalties would allow DFEH the flexibility in enforcing, both minor and egregious violations of the law, depending on, what's appropriate in the circumstance. So my second suggestion here is, that numerous state and local laws across the country. I meant to say that, numerous state and local laws already do this across the country, impose monetary fines. And I'd like to point out that the District of Columbia has a great incentive structure in which they split the monetary penalty between a complainant and the government coffers when a monetary penalty is imposed in order to incentivize complaints to be brought forward. Second, across the nation, agencies like DFEH enforce ban-the-box laws, but so too do attorneys generals and departments of labor. And all of them have different tools, enforcement tools at their disposal. So if there's some potential for sharing the enforcement through legislative change, that's an additional suggestion. Third, strategic enforcement partnerships with community groups. They can build overall enforcement capacity and help focus enforcement efforts on, industries that are rampant with violations, or employers that will have, the greatest overall impact. This was discussed a bit earlier. Now, one example of such a partnership is relatively new. The California Labor Commissioner's Office began a few years ago an anti-wage theft enforcement partnership with 14 workers' rights organizations. The partnership encourages groups and their members and clients to report violations, and assist the agency with strategically focusing its investigations and enforcement actions. You heard earlier from Professor Tilton of the Inland Empire Fair Chance Coalition, and while that coalition has worked some with DFEH, reporting violations, coordinating trainings, a more formalized partnership like this, could have additional benefits, enhance transparency and build trust among community groups and workers, to the benefit of enforcement efforts. And so I'll keep moving. And finally, I'll just note one step that Minnesota has taken, which is to create on their website just a simple form specifically for reporting job applications that violate ban-the-box laws. So it's less burdensome than filing a full complaint, which is unnecessary for some simple, obvious violations like one that appears on an application. And this would be especially useful if monetary penalties are provided for in the future. So since I have this audience of folks interested in improving the situation in California, I'm going to shift away from the Fair Chance Act and just highlight some further statutory and regulatory improvements that California might consider to enhance employment opportunities for people with records. So first is one that might be a bit already known, fair chance licensing, which refers to reducing barriers to occupational credentials. So just background in California, over 20% of jobs require a license or certification. That includes growing industries, healthcare, childcare. Licensing authorities generally have broad discretion to reject applicants because of a record. And I'll note one recent law that was passed to improve the situation somewhat for some licenses, specifically those under the Department of Consumer Affairs. It made some improvements, but there are lots of exceptions and further improvements are needed. So some of those further reforms needed. Banning the box. Meaning delaying background checks until the applicant is determined to be otherwise qualified for the occupation. You know, that again, just like with employment, removes the stigma of a record from the agency's initial assessment. So first determine if someone's qualified, then do the background check. That would also, you know, reduce the number of background checks that need to be done overall. Also eliminate self-reporting of records, which results in a candor trap. Basically, it's, you know, it can be difficult to accurately remember the details of a record and to know which records need to be reported, which do not. And so the result is that applicants unintentionally appear untruthful on their applications. And so this is, you know, for licensing in particular, if a background check is going to be run, why require the self-reporting also? It just puts people sets people up for failure. I'll note that licensing agencies retain access to information about, you know, expunged offenses. We don't really have true expungement in California. So eliminating access to expunged or dismissed records would be one way to allow people to move forward more fully. And I'll note that AB 2138, the law that passed in 2018 that I just mentioned, did not apply to childcare workers and EMTs, which are outliers in California because they include lots of blanket bans and other overly broad restrictions. So efforts still are needed to improve those in particular. Now I'm
moments, Ms. Avery.
I'm almost done. All right. I was just going to highlight, I'll stop there, but I was just going to highlight some other things that states have done. So New York has made it an unlawful discriminatory practice to deny employment on the basis of a record if it's not directly related to a job or occupation. So that's, I think, directly relevant to this group here, taking it a step further and making it an unlawful discriminatory practice to do that if they didn't consider certain factors. And, you know, the other most relevant thing that I would note is that the Washington Human Rights Commission, which is somewhat of an equivalent to DFEH and FEHC, they enacted regulations pursuant to their general employment anti-discrimination law. And those regulations provided that, you know, consideration of a record states flat out is not justified by business necessity if it occurred more than 10 years prior, and if it doesn't relate to the duties of the job. So those bodies took it upon themselves to impose a look back limitation through regulation by saying that, you know, it is not justified by business necessity if the record occurred that long ago. So I would highlight that as a possibility for regulatory improvements under general anti-discrimination authority. And I'll leave it there. I will save the rest of my slides for another day. Thanks so much. How do I end screen sharing?
Thank you so much. Next, we have two individuals who will be presenting, Shelly Winner and Jason Ford. Shelly Winner is a restorative justice activist whose goal is to change the world by advocating for justice-involved people, all while helping companies improve productivity and revenues. Shelly, a technology specialist with Microsoft Corporation, believes that someone has to challenge the societal stigma that prevents companies from hiring people with criminal records, and Shelly has taken up that mantle. Shelly is very active in the restorative justice movement in San Francisco and wants to educate the public about the benefits of hiring the formerly incarcerated. Through her work with Winner Circle, she is closing the gap between soon-to-be released inmates and technology companies by developing and delivering training to inmates and helping technology companies create internships for justice-involved individuals. 76% of people released from prison will reoffend and return to prison, and Shelly is working to turn the tide on this statistic. Jason Ford is a highly accomplished and successful sales executive and leader of teams in the tech industry with over 20 years of selling complex technology solutions to Fortune 500 companies. His field experience, as well as his professional experience in recruiting, building, and motivating people, led him to create the Capacity for Success model. Using a servant-based leader approach, Jason is determined to help people define success and assess their capacity to achieve it. Jason also serves on the board of directors of Goodwill for San Francisco, San Mateo, and Marin counties, the mission of which is to equip low-income individuals and those with barriers with skills required to succeed in the 21st century job market. Shelly and Jason?
Hey, hello, hi everybody.
Hello.
So I ended up going to prison for drugs. I grew up in a household. My father was a drug addict and a drug dealer, in and out of prison most of my life. And statistically, they say that 76% of children follow in their parents' footsteps. And like my father, I ended up becoming an addict myself and a drug dealer, and ended up getting arrested by the federal government. And right after my arrest, I found out I was pregnant. And I knew at that time that I needed to turn my life around. If I didn't, my son wasn't going to have a chance. And there was no way that I was going to be the same kind of parent to my child that my father was to me. And so I enrolled myself into treatment while I was fighting my case. And then once I got to prison, I also did another treatment program. And what's amazing is these treatment programs taught me a new way of life. They taught me a new way to think. And you don't know what you don't know, right? Until you're taught a new way. And so once I learned this new way of life, I became empowered to make better decisions. And long story short, I ended up getting out of prison. And with this dream, this desire to essentially take over the world. And I really wanted to work in tech. I didn't know how I was going to get there, but I figured, getting my college education would be a good start. But I always knew that I had this barrier, of having a criminal record. And I ended up applying at the Microsoft store. And because of Ban the Box, I was able to get an interview. And I prepared my butt off for that interview. I went in and I nailed it and I got the job offer. One of the most exciting moments in my life, because here I was fresh out of prison and now I have this job offer from, one of the biggest tech companies in the world. And I knew my life was going to change. And then the background check, I had to fill out the background check, and I knew that it was going to get flagged. And all of the research that I had done to see, if this company would hire me or not, all led to no. That this company did not hire anybody with a record. So once the background check came back, my job offer was rescinded. And during this time, while I was waiting for the results of that background check, I learned about the Fair Chance Ordinance. And I was able to leverage them. They basically helped me fight and get my job back. I was so excited that I actually got my job. And when I came to work, I was just beyond grateful to be there. And my attitude showed that. And I worked really, really hard. I got my first promotion in 6 months. And about a year later, this incredible person named Jason Ford had heard about my story and actually reached out to me and, said he had wanted to meet me. and wanted me to apply for a sales position on his team. And so I did. I ended up meeting him, and he was just such an inspiration. I mean, he never judged me once for my past, and he really truly believed in me, and made me feel valued and important. And I ended up applying for this job. Although I didn't get that original job, I did get the second job I applied for. But here I came across the background check again, because every time you get a promotion, you got to do that background check. And I thought, oh man, here we go. And you know, this time I was transferring from the retail stores into corporate, so I wasn't sure what was going to happen. And long story short, HR did not want to give me this job. They were very hesitant. But you know, Jason, being my committed ally, actually stepped in for me, challenged them, and said, hey, look, I don't care what this girl's done. That's not who she is today. We want to offer her a second chance. And I was able to get the job because he actually stood up for me, and changed my life, you know. And here I am 4 years later, and I'm so grateful that I had somebody like Jason actually, you know, be my committed ally. And I'm so grateful for that, for him standing up for me and fighting for me. And I wouldn't be here today if it wasn't for him. And with that being said, I'm going to go ahead and pass the mic over to Jason so that he can share his story and his experience. Jason, go ahead.
Yeah, thanks, Shelly. You know, I mean, it's tough to follow a story like what Shelly has. And what's interesting, I found out about Shelly through some mutual connections at Microsoft. And one of them approached me and said, hey, you should watch this TED Talk. And it was Shelly giving a TED Talk talking about herself on saying, she starts it off with basically saying, what if you were known for the worst thing that you ever did? If that were the only way that you were known. And so when we go through this process of interviewing Shelly and getting to know her, she was being interviewed by a manager that worked for me. So her direct manager was someone that worked for me. And as she said, we didn't hire her for the first job, but then kept pursuing the relationship because we believed in her. And this other job that came up, we decided we wanted to offer her this role. And it wasn't just me and the manager that worked for me, it was also the people on the team and the entire interview panel of people that Shelly met. And so as a result of that, so this manager happened to be a Black man. When he goes to try to get the offer to be made to Shelly with HR and the recruiting teams and so on, he was met with a lot of resistance. And let's make clear, Shelly was already a Microsoft employee. Shelly worked for our Microsoft retail stores environment, and we were talking about hiring her in Microsoft corporate. Already an employee, and she was having to go through a situation where she was going to have to check the box again or get turned down again because of what happened in her past. The reason I point out about the position of her manager is because I'm not sure exactly his position on how he felt about trying to escalate this, but he and I had a lot of conversations about it, and he didn't feel comfortable that he was going to get that support. And this is where I'll lean in with you and tell you the way that I see things is a little different than others, which is that I'm not going to allow my white privilege to be wasted on me. I'm going to take my white privilege and make it where it works for other people to get equality or to get benefit for themselves. Because I realize the position I'm in and have been given is something that I need to help others get. And in that conversation with HR, you know, I told them a couple different things. I said, you know, one, there are 70 million people in this country that are formerly incarcerated. Do we really believe that all of those people should not participate in working in our industry, or should not be candidates for us to work at Microsoft, or who won't be able to help us make the world a better place? Because that is what our company values are, and that's what we espouse to our employees. So when you put things in those terms, and I went and fought with HR for a couple of weeks, not really fought, we conversed, and we had to make each other aware of our position, and we had to alter our position based on the system that worked for a white man that didn't work for a woman who was formerly incarcerated. So make no mistake, the system works the way it was designed, because it was designed by people like me for people like me. It was not designed for people like Shelly. And so if we're going to change that system, you have to have forceful advocacy, and you have to have willingness to lean into that conversation to try to change the position. And in positions like mine, or people like me that have national responsibilities, have large teams, and have, been successful, like I said, we have to be willing to use the white privilege that we were given in a way that will help change the system for others, instead of sitting back and saying, well, the system is set up this way, Shelly, no, we can't hire you. And her manager that was hiring her, I would have had to tell him the same thing, we can't hire her, so we just got to move on to the next candidate. So the world is a better place by people like Shelly for a number of different reasons. I'm going to give you a man named Jeff Henderson, who grew up in LA and San Diego and was running a $35,000 a week cocaine operation. After he served his time, he went out and became an executive chef at Cafe Bellagio in Las Vegas. He also wrote a best-selling book around focusing on giving back. And now he helps people in youth communities to try to work for his catering company so they develop new skills. Roy Castro jailed for 15 years after he went into the Strive program after he was paroled. He worked his way through various jobs and now runs a multi-million-dollar ice cream business. There are lots and lots of stories that we have here. Shelly is becoming one of those stories. And do we honestly believe it's okay for us to sit back and not try to make the world a better place? My position in this is to try to help Shelly launch into that world to be a better person, to make the world a better place, for us all to become more aware of what we do. But the challenge I have for people that are in positions of mine is if you're not going to do it, it will not change. If you don't become that advocate, it will not change. And if you're not willing to have tough conversations and put yourself out there to be exposed a little bit, it will not change. And the way I look at it is that white men have had their time in history. We've ruled countries, we've run companies, we have been a dominant figure forever in leadership positions, and it's time that we try to build a balancing act to get other people those equal rights or equal opportunities in different ways. So if I'm going to make that change, I have to lean on the system that was built for me. I have to expose the system that was built for me. I have to help others understand how that system works so they can take advantage of that system. So for Shelly to come in and just fight against the way the system works never would have worked. But for Shelly and I to talk about how we can do this together and how we work through this, and I can explain to her, here is the translation of what you see. Here's what that means, and here's how it works inside that system. Helps her apply more aptly. It helps her be more intelligent about how she speaks about herself. It helps her be more authentic. And it helps her also look at opportunities in ways that she hadn't considered before. So a lot of this is obvious. And these aren't hard concepts. These are tough things to do. And they're hard things to own up to. And in corporate America, I would propose in technology, if we only do coding and build artificial intelligence systems that are built and written by white men, we have not changed anything. We've made it worse, because now those systems, those algorithms, those software devices, all of the things that you use have a narrow perspective of the world because they're written by the same people that we are changing the system. So getting more women to be coders, getting more people that have had diverse backgrounds to come in, or even have learning disabilities in some way, shape, or form, or have been justice involved or whatnot, to come into this conversation and be able to help change the way we're coding, the way we're developing technology, the way that we're asking people to do this. All of that, to me, is how we change the system, by giving people opportunity. And it requires tough conversations, a strong will, and a forceful ability to just tolerate emotional pain. If Shelly can do it, I believe I can do it.
Thank you, Shelly and Jason, and I'm sure you'll have questions at the end of the session. Next, we will have a representative from Community College up north. We have an individual by the name of Roger Viet Chung, who serves as a faculty member and chair of the Department of Ethnic Studies at Laney College of the Peralta Community College District. At Laney, Roger directs Restoring Our Communities, a reentry program that supports formerly incarcerated community college students. Originally from Oakland, Roger is also the lead instructor and curriculum developer of Asian Prisoner Support Committee's Roots, Restoring Our Original True Selves program, an Ethics Studies and Healing Centered program at San Quentin State Prison. Roger?
Hey everyone from Oakland. So first, I'd like to express my appreciation to the California Fair Employment and Housing Council for allowing me to share some of my experience working with formerly incarcerated students and staff at Laney Community College of Oakland. And so as mentioned in Mr. Sandoval's warm welcome, I'm Roger Viet Chung. I'm the chair of the Laney College Ethnic Studies Department and founder and faculty lead of Restoring Our Communities. We call ourselves ROC, our college program that supports formerly incarcerated and justice impacted students since around October of 2016. And since then, we've seen about 400 or more students with justice-related barriers to education and employment enter our program. And so our work very much converges with a lot of components of California's Fair Chance Act. And I'd like to share two perspectives of these intersections today. And so first, I'll be sharing experiences in hiring, inclusive of formerly incarcerated classified staff and student workers with conviction records. And then secondly, I'd like to share some of our partnership work with the Alameda County Public Defender's Office and our collaborative efforts to offer efficient record relief to formerly incarcerated students who are preparing for the workforce and university transfer. So let me just start with the Fair Chance Act. And so, I think a lot of folks know that formerly incarcerated students are becoming more and more visible on California community college campuses. And so this visibility has recently been recognized by the state legislature. The passing of AB 2341 in June of this year allows for the use of Student Educational Achievement Program dollars, SEAP dollars, to support formerly incarcerated students on our campuses. So these dollars can be used for both direct support and for hiring appropriate staff. And so hiring formerly incarcerated people to lead these efforts has been recognized as a best practice, both in the research literature as well as from students themselves. And so backtracking back to 2016, when I started ROC, I really wanted to hire formerly incarcerated people. And so I started by hiring 2 formerly incarcerated staff as independent contractors, no benefits, no job security. I mean, they worked so hard and their efforts led to a bunch of institutional buy-in, philanthropic dollars, and eventually an innovation award granted by the California Community College State Chancellor's Office. And so by 2018, ROC had new resources to develop and hire 2 full-time student service specialists who would be classified, who would be unionized, and to provide trauma and healing informed support for formerly incarcerated students. And so with the Fair Chance Act also coming into fruition around the beginning of 2018, we asked a really important question. You know, our community colleges more than ever are welcoming formerly incarcerated students on our campuses and in our classrooms. Will our colleges also welcome the most qualified staff to support them? And so for a relatively inexperienced program lead and director like myself at the time, it was really unclear how the Fair Chance Act and the California Education Code would interact in the hiring process. And so luckily in 2018, the State Chancellor's Office released a legal advisory that would offer clarity to the college's administration and the college district's human resources vice chancellor. You know, although the Fair Chance Act would not specifically apply to college hiring in this case, with the exception in the case of student workers, and I'll talk about that shortly, the State Chancellor's legal advisory recommended adopting both the spirit and the framework of the Fair Chance Act. And this was particularly important in illuminating things like the 5 years of proven rehabilitation component of the California Ed Code, which allows local college authorities to define when rehabilitation begins for a candidate. And so while the Fair Chance Act was not leveraged as policy specifically for these particular hires, its framework and really most importantly, its spirit, right? To really get California community colleges to align with these new state initiatives and provided needed guidance, needed language, and really supported human resources in crafting local procedures. And, you know, I'll reference, you know, one of the panelists earlier in the day that really kind of highlighted the importance of like reducing liability for an individual that has to make this decision. And in a lot of cases, it's just one person at a community college district. And so the Fair Chance Act actually does have a big impact on our student workers. And so in addition, it has been really effective in ensuring that student workers have destigmatized opportunities to contribute to the college. And so not requiring conviction disclosure at point of application has been crucial in giving our formerly incarcerated students, our rock stars, confidence to engage in federal work study programs, student worker opportunities, as peer mentors, as clerical aides, as career and technical education aides, academic tutors, and much, much more. And so when we kind of think about the Fair Chance Act as it intersects with the educational industry and the California education system and its ed code, I think the industry really holds both promise and peril, right, for those with conviction records. And so on the one hand, schools and academic institutions are one of the largest employers in the state of California. But on the other hand, as mentioned in previous testimony, conviction records present really onerous obstacles to working on campuses and in classrooms. And so I think there's some work to be done there in really leveraging some of our biggest employers in the state. And so another thing that I'd like to talk about today is another component that I think precedes the Fair Chance Law, but certainly is strengthened by it. And that's really thinking about expungements or record relief. So in California, we're going to refer to these as dismissals or reductions as opposed to expungements. But in addition to hiring needed support staff, what Laney College and the ROC program do is that we also commit to supporting formerly incarcerated students' workforce participation and transfer velocity. And I think the Fair Chance Act will certainly ensure more welcoming climates as our students graduate into the next phases of their lives. But it's also reinforced, if not made more powerful, our record relief program with our partners, the Alameda County Public Defender. So I want to point to one of the components in particular in the Fair Chance Act that I just grabbed off DFH. And so considering information about arrest followed by conviction, participation in pretrial or post-trial diversion programs, or convictions that have been sealed, dismissed, expunged, or statutorily eradicated, right? And so employers are prohibited from doing that. And I think by incorporating a clean slate program on a community college campus that's doing training for employment, that's transferring students into bachelor programs that are going to guarantee and strengthen, right, a worker's earning potential, I think these are crucial things that we need to do to move forward. So I'll talk a little bit about our pilot. And since around 2018, ROC and Clean Slate has resulted in numerous record changes for about 30 formerly incarcerated students in our humble pilot. And so the pilot addresses multiple gaps, I think, identified in the research, both inside and outside of California. A robust study in 2019 in the state of Michigan describes this phenomenon called an uptake gap, or the extremely low rate of expungements, dismissals, or set-asides, as they describe in Michigan, of folks with criminal records within their first 5 years of eligibility. And so according to these authors, Prescott and Starr, in the state of Michigan, only about 6.5% of eligible folks receive an expungement or a set aside or a reduction or dismissal within 5 years of eligibility. And it really asked us why, as we thought about scaling our relationship with our county public defenders. And so be it in Michigan or in California, one of the big things that stands out is lack of information. And so lack of information appears to be a significant contributor to what is described as an uptake gap. And so people may not have access to their rap sheets that detail their conviction histories, nor the legal literacy to interpret them. And so in our Clean Slate pilot, half of our applicants reported feeling uninformed about their criminal records before applying for dismissals and or reductions. And so professional development trainings by the Public Defender's Office offered ROC staff a framework to identify potential eligible convictions that could be remedied. And our ROC staff, as a result, right, of really doing intentional work at the HR level of hiring formerly incarcerated folks, provided a healing and trauma-informed space to really be able to have safe conversations with our students and our clients about their past histories. Our staff have certainly have had barriers to employment and housing because of their records, and really being able to be the peer mentors that allow for folks to share without feelings of judgment has been really, really crucial, and what we think has really closed a lot of the uptake gaps, at least for a lot of formerly incarcerated students on our campus. We're looking to scale that right now, and we're looking to do far more legal literacy stuff. But I think those are some of the preliminary things that we can report. Of our humble 30-person cohort, about 14 folks have either a certificate in an in-demand industry, an associate's degree, or have transferred to a four-year school, including UC Berkeley. And so, one of the things that I think is important as we kind of think about this pilot with our county public defender is, most of the research really does demonstrate that some sort of record relief, either bias or actual reduction or dismissal, certainly accelerates a person into the workforce. But some of the things that we've seen is that oftentimes, right, their participation in the workforce may not be a living wage participation. And so some of the things that we're hypothesizing is that prior contact with the criminal justice system may also really disrupt traditional pathways to educational training or acquisition of in-demand skills in a dynamic marketplace. And so, you know, coupling these programs like Clean Slate and Fair Chance with California community college programs and supporting programs that are employing and supporting formerly incarcerated folks, I think can be really crucial next steps in really thinking about equity as far as employment. And so I'll stop there, but I do want to thank everyone for having me and letting us tell our story here from Oakland, California at Laney College.
Thank you.
Thank you so much. Appreciate your remarks. And also, Laney, when we were planning to hold this in person, was going to generously agree to be our host. And while COVID had prevented us from meeting in person, we owe a debt of gratitude to Laney College and its commitment to host our event. And hopefully we'll be able to host one there in the future. It's my privilege to be able to introduce our next speaker, Michelle Garcia. Michelle is a system-impacted woman and advocate who believes in multiple chances. She is a wife to an amazing supportive husband, a mother to 4 strong and resilient children, and a grandmother to a 3-year-old grandson. Michelle found coming home presented challenges she never expected. She experienced deep depression as she transitioned from Garcia inmate number XXX back to her role of wife, mother, and community member. Today, she continues to use her insights and experience to help the incarcerated and their loved ones. Michelle has worked as a regional coordinator for Center of Restorative Justice Works, reuniting families for Mother's and Father's Day. In 2016, she carried this same passion to Defy Ventures as their family program manager. Michelle is currently working with the Anti-Recidivism Coalition as the project coordinator at the Ventura Training Center, a program that trains individuals paroling from inmate fire crews in a California State Firefighter Academy while providing them with useful skills as they re-enter society. Michelle, thanks for being with us today.
Thank you. Thank you for inviting me. And thank you for everybody who has participated in the vulnerability that has been shared. Thank you, Shelly. Much respect. Just hearing that bio that I have lived is just when you hear the words, the impact that they have, and instantly going back to that. And but since that bio tells you my story of prison, you know, it's a story that we all tell and that we all unfortunately know. But it's that story of coming home, and it's often what I refer to as the second sentence. I didn't know that I was going to be sentenced twice when I went to prison. I really thought that when I paroled that there would be a few challenges, but there wasn't anything that I couldn't overcome, especially with the support of my family. My husband is more than just amazing. You know, he kept our family together the entire time I was gone. And for a man to do that is pretty commendable. If you ever look at the visiting data for women versus a men's prison versus a woman's prison, you'll notice that the men's prison is always full of visiting, but the mothers are the ones that are always impacted the least and have the least support. We have been, you know, neglected from the beginning, which really, to me, doesn't make much sense because we're the ones that keep families together. You know, we are the ones that keep, you know, things intact, and you would think that the community would want to support us more, but that's a different tangent. I'm just going to share my experience. In my incarceration, my last year and a half, I was fortunate enough to be endorsed to a fire camp. So I went to Malibu, California, where I was an incarcerated female firefighter for about 2 years. I worked on about 12 different fires. And even though it was the most challenging work I'd ever done, and I have zero desire to ever work like that again, I got some very, very important, I got a foundation built. I really got my foundation. I was able to give back to the community that I had stolen from. I was able to start healing, and I was starting to forgive myself because I was giving back. I was participating back into the community. And I think that is a key piece, because that's what we're missing, is we want to give back, and in return we heal, right? And then in return, the community is safer, and it's just this win-win, because we feel a part of, instead of excluding us, we're actually participating in what you want, and that is a safe community. And so it really is, what's wrong and what needs to be fixed is people just need to wake up and realize this overlooked pool of people of previously incarcerated. I think I just really want to focus on the firefighting piece, because this discipline and dedication that we do, and who doesn't think of firemen as heroes, right? I think everybody thinks of firefighters as heroes. And so here I am working with people who are heroes. After about 1.5 years of this, I started having the same work ethics as them. I started working like them, I started thinking like them, and I started acting like them. And so I start thinking, wow, you know what? I'm not too far off from this hero. Maybe I can do this. And so we're giving back, we're healing, and then we come out and we can't work with that skill set that we just learned inside prison. And it's like, that's where people were happy. That's where they found their passion. That's where, self-esteem is established. But yet go back to being something you scrape off the bottom of your shoe when we parole. And so Ventura Training Center is an amazing program. It's the first of its kind in the world, okay? Not just in the state, but in the world. And it is taking people who have been incarcerated as a firefighter, and they parole here, so they're completely free. Freedom is here. And it's an 18-month program. And in that 18-month, they get their CAL FIRE Basic Firefighter 1 certificates, and they're eligible to work for a fire agency, any fire agency. However, they aren't eligible to apply for many because of the EMS. So that would be the difference between a firefighter 1 and a firefighter 2 position. And municipal agencies prevent you from applying, being hired if you don't have your EMS. And so it's this double-edged sword. They won't say we won't hire you, but they all have these loopholes. And you're competing against a high population of people who do meet all the qualifications. So you're always continuously overlooked. The really cool thing about VTC, Ventura Training Center, what I often call as Ventura Transformation Center, is because these lives are changed. So for the few years that you're in prison and working in that healing that I was talking about, now you come here, and for 18 months, it's elevated up. The discipline, the dedication, the leadership, all these qualities are brought in. And that's the key piece, is that 18 months. So you can get these certificates in actually 5 weeks. So all of this time is life skills, it's leadership, it's healing, it's processing that trauma. So inside, you can program all you want, but until you can apply those steps that you've taken in the free world. So these men are home facing the hurdles that we often face while having the support here. And what has happened is, this is our second fire season. So this program started 2 years ago in October. So this is the second fire season. And what we're seeing is people are calling and saying, we want to know what Ventura Training Center is, and we want to hire everybody from there. Why? Why are our guys sticking out all of a sudden in one fire season? What has made them bump up so high? And it's their work ethic. They're the first ones there. They're the last ones to go home. They do whatever dirt job that you want them to do, and they do it with dignity and respect. And there's power in seeing that discipline and the way they carry themselves. And it's just a matter of people have been spending time with them for the last year and a half, working them up to this. And so the agency I want to really appreciate is Orange County Fire Authority, who hired their very first previously incarcerated individual this last fire season. And the reason why is because 2 of our candidates went and applied there. I found this job posting and I shared it with these men and they all applied, but we couldn't find out if they would hire previously incarcerated because it never said, and I couldn't get an answer. So I just encourage them, just go for it. At least it's a good experience of interviewing. Well, their chief was so impressed with these men that he came out here. He drove out here from Orange County and said, "What the hell are you guys doing? Because I need to know." And he said it was not a choice. He called HR and said, "I will hire these men. One of them turned down the job, but one of them did go work there. And it's been an amazing experience to see the rest of the world slowly wake up to the quality of work that these men have. Me personally, like I said, I have no desire to work this, but I have the pleasure of walking alongside of these men and encouraging them. Some of the problems of coming home, of reentry that I've endured is just finding myself again, simply finding myself. So thank you for your time, and I'd be glad to answer any questions if I can.
Thank you, Michelle. Really appreciate that. And hopefully you can stick around since we've got a few more speakers, and then we'll be able to take up question and answer. Moving right along, it's my pleasure to introduce our next speaker, Felicia Espinosa. She is the Fresno Reentry Women and Employment Initiative Site Director and Senior Staff Attorney at Root and Rebound, a nonprofit organization focused on restoring power and resources to the families and communities most harmed by mass incarceration. In this capacity, Felicia's system impacted people as they navigate legal barriers in employment, occupational licensing, housing, family reunification, and record cleaning. Prior to joining Root and Rebound, Felicia worked as an assistant city attorney for the city of Fresno. There she handled a variety of cases, including tort litigation, labor and employment, and code enforcement. Felicia also worked at California Rural Legal Assistance, exclusively representing agricultural workers as they asserted their rights to a workplace free of retaliation, discrimination, and harassment. In addition to her legal work, Felicia has taught courses in the Women's Studies Department at Fresno State. She received her JD from the University of San Francisco School of Law in 2009. So thanks for being with us, Felicia.
Hi, good afternoon, and thank you for having Root and Rebound and having me present and testify on behalf of just the work that we're doing, but also very much here on behalf of the Central Valley. Similar to what I've been hearing by other panelists about kinship and the margins, that very much is often us living in the Central Valley, living in Fresno, which is often on the list in terms of the least economically inclusive city, even though we are a minority majority, which means that the city of Fresno we're a majority of people of color. Yet when it comes to inclusion, when it comes to economic health, there's a lot of racial inequities that persist here in Fresno, and more so in the Central Valley as well. Born and raised here and raised by my mama, my single mom, who raised us both as a teen mom with twins. So gender justice is huge to me, and inequality when it comes to economic injustice for Latinas, and when it comes to women of color, is something that's very near and dear to my heart. The Central Valley, unfortunately, has high rates of poverty, and that is not because of individualism. That's because of what has been talked about before. It's by systemic barriers that were placed right on us. It's been disinvestments in communities of color. It's disinvestments in communities that where immigration is an issue, where language barriers is an issue, and where the criminal justice system over incarcerates Black, Indigenous, and people of color in a way that doesn't incarcerate white communities, right? It's not that people of color are doing more crimes, it's that they're being over-policed. So we heard that before, you know, that was part of what our panelists are saying. And I think when it comes to like some of what's going on is that there needs to be a paradigm shift. There needs to be different conversations that Director Kish talked about in terms of an understanding of what the over-criminalization of people of color has done to us, because there is this stigma that we automatically think that it was something an individual did that led to that, and not understanding the differences. Here, when it comes to the Central Valley, a lot of those conversations may be happening and there's starting to be more realizations in the Bay Area, in LA, in other areas of California, but in general, the Central Valley hears about everything later, right? We just do both the good and the bad, like the fun stuff, the good songs are a couple of years late, but then the good laws that are protective a couple of years late as well, right? That's just us, that's the Central Valley. So we're hoping that like when it comes to these changes, these conversations that are happening, that's also gonna bleed out to us because we have historically been uninclusive to people of color, and just huge disinvestments. In terms of adding to what has been talked about before, I think a prime example is of the record cleaning conversation that was had in terms of Laney College and relationships that are able to be built in other areas that benefit people who have historically been kept out in a way that isn't here in Fresno or in the Central Valley. A lot of in addition to doing fair chance hiring work, I also do work in occupational licensing, and then we also do work in record cleaning. Here in the Central Valley, when it comes to record cleaning, there isn't that many resources that a person can go to. There isn't that many other nonprofits in a way that there is in obviously San Francisco and LA, but in other parts of California as well, that will help you with that record cleaning, which then would benefit you under the Fair Chance Hiring Act, right? Because it may not come up, shouldn't come up when it comes to your general background checks. But here we're not having that. There's not that many places that people can go to help you with that record cleaning. And there isn't that understanding, I think, with the government officials that can help you with that. There isn't hearings that are being set. There isn't this disinvestment to help people clean that up quickly that we have in other places. I think that, what other people have shared and what Michelle very, very well spoke about is the difference when it comes to women who are system involved and who are from incarcerated versus men. So our program focuses on women here in Fresno because they historically have been kept out, and there isn't that investment even when there comes to criminal justice reform for women as there is for men. Right, Michelle spoke about visitation schedules and how there is that support of women showing up for men in a way that we don't see when it comes to the female prisons. And here in the Central Valley, we have Chowchilla, we have the biggest female prison in the world, not even just in California, not even the nation, but in the world. And that's what we have here, but we also don't have the same resources. We incarcerate, but we don't help them when women are coming out. And women are the primary caregivers for their children. Right, we know that both in the people who are formerly incarcerated, but just in general. So we really are separating families when we do this, and we're quick to do that here in the United States, but for sure in the Central Valley. But we're not quick to give that care and that kinship that that we learned about today, and we are starting to talk about in other places as well. But the reason why we focus on women is because they have been excluded, and it is not only just a criminal justice, racial justice, but it's also a gender justice issue, because it's needed, right? When we talk about jobs that other people, we heard today too about the living wage jobs that are available, not just for people who are formerly incarcerated, but living wage jobs in general are gendered. Right? When we're talking about firefighters, only 4% of firefighters are women. That's just the gender justice issue when it comes to living wage jobs to be able to support families, right? So there is so much intersectionality especially when it comes to Black, Indigenous, and Latina women who are system involved. That is why we should be talking across the aisles, right? Talking about all the justices and all the ways that we can take away some of those barriers and not just talk about the criminal justice system, not just talk about racial justice and stay in our lanes, or just talk about gender justice and stay in that lane. These are intersectionalities that, you know, Black, Brown, Indigenous women have been talking about and know it, and you know, it's part of our daily lives. And I think we're starting to talk too for the other people that isn't something that they know on a day, you know, isn't part of their daily lives. Other things that we're seeing here in the Central Valley, very much so, is, as I said, it takes a little bit longer, but people are starting to know about the Fair Chance Hiring Act, right? It was very different in terms of how many of those procedural day-to-day violations I would see in 2018 versus how I'm seeing them now. But there's versus now, they're doing the procedural job postings, right? They're doing the procedure notice. You're very limited 5 days, and unless you're ready to go, 5 days is nothing, right? Like to respond to that. You know, unless you're ready to go, most likely you see that self-selection out. You know, we heard about that, right? But we also see that self-selection out even before. You know, just someone saying like, they're gonna look at my record. Like I've heard about the Fair Chance Hiring Act. You know, some of our program at Root and Rebound also includes for people who are currently incarcerated. So you know, Sandra this morning leads a lot of that work with Jamie. So they're starting to prepare for that before they're coming home, but at the same time, they still know it's gonna be looked at. Right? So there is that self-selecting out that the professors talked about, and ways to be able to change that, so that we are changing some of that inequity issues, some of that gender justice, some of that racial inequality that is part of the United States, and especially here in the Central Valley. I think what we're also starting to see, and why our work is focused on women, is because of what COVID-19 exposed, right? Our frontline workers, our low wage workers who are frontline workers, are all women of color, right? And a lot of times so it's already underpaid and undervalued work, and now we're using the word essential, and they've always been essential, right? But now we're starting to use that language. But that's also, that frontline work is a lot of times that have those loopholes or those exemptions that the Fair Chance Hiring Act doesn't necessarily cover. It would be where occupational licensing is involved. It's where, you know, where then they are working with vulnerable populations. It's like the difference when it comes where those loopholes are for positions where women of color are already being undervalued and underpaid. And now we're even excluding other women who, as Michelle said, want to give back. Like the first thing that they want to do are caregiving positions to take care of other people. So we're losing those people who do it best, right? We've been doing it. Women of color have been doing this, right? So I think that in terms of what I want to say for today is very much make sure that the Central Valley is not only included, but centered, right? We are the margins. The Central Valley in general has inequality that they're working through, and the Fair Chance Hiring Act and, you know, the system involved people intersects with so many other ways that we can make sure that we're righting the wrongs that this United States has done to a lot of our people. So thank you.
Thank you, Felicia.
Thank you for your remarks, Felicia. Our next speaker is Robert Smith. Robert grew up in severe poverty in a violent home fueled by alcoholism and drug addiction, making the transition into criminal activity not a huge leap. March 6 of 2000, he walked out of prison with his GED and $200 in gate money. Noticing the revolving door, he was truly worried if there was any hope for him to succeed on the outside, or whether he'd just be another recidivism statistic. All I kept hearing was, I couldn't find a job, or I couldn't find a place to live. Staying focused on a goal and telling himself, I'll take any job, and that a bad day at work is better than a good day in prison, was a constant motivation. Robert has worked for the past 20 years in the nonprofit sector across the United States and in the United Kingdom, wearing many hats, starting in his first position as a volunteer janitor in a job readiness program, to serving as an adult educator, program manager, and executive director. Today, Robert serves close to 500 justice impacted San Diegans a year. Currently, Robert is the director for Center for Employment Opportunities in San Diego, one of 30 CEO offices nationwide. Enjoys teaching and interacting at employee orientations on work crews and offering his own story of uncertainty and accomplishment. Robert, thanks for being with us today.
Yeah, thank you. Hopefully you guys can hear me with the face mask on. We have a activity going on in the building, so obviously we're taking all our necessary precautions.
Well, yeah, we can hear you great.
Okay, perfect.
Thank you.
So yeah, thanks. I mean, just hearing everyone's story today, you know, just such great, I feel like I'm in great company with the people that have sort of been there, done that. And I think that, you know, even some of the programs, I think someone actually mentioned the Strive program. That's actually the program that I came out of when I came out of prison, I actually went through, graduated that program, and ended up working there for probably about 10 years. You know, it's definitely a long journey in that process. And, you know, today it's amazing to see all the representation that is here, you know, doing this work. I remember coming home and this not nearly being the topic of discussion, even the program that I was coming out to. I think I was the only person that had actually come home from state prison. So now, you know, to be able to serve as many people as we do and be a part of Center for Employment Opportunities, doing this across the country, and working with an amazing group of folks that we have people that work on the policy side. I find myself really lucky. I get to work on the program side. The policy stuff sounds fun, but I'm not nearly as good at that as I am actually on the ground with the clients and with the teams that serve the clients. I did prepare a slideshow, so I'll go ahead and share my screen as well. So make sure everyone can see this. Did that come through?
Not yet. There we go.
Okay. All right. So yeah, these are all the offices. We have 30 locations across the US. And interestingly enough, some of the partners that are around the table locally, we have some affiliation with a variety of folks in some of your offices. So thank you for all the work and support. And your colleagues have been great to work with here in San Diego. So, you know, I think it's, you know, I will speak more to the workforce engagement aspect because that's really what my expertise is more around. But I think it's really important to talk about, oops, let me jump the slide there. There we go. Our vision is that anyone with a criminal record who wants to work and has the preparation, that they have the preparation and support to find a job, stay connected in the labor force, and that we believe anyone, regardless of their background, deserves that second chance. And you know, even in our hiring practice, my office here in San Diego, I think we are 50% or higher formerly incarcerated individuals actually working, and we have a staff of close to 34 people in San Diego. So a lot of folks that went through the program actually have come back and are now serving in, you know, community-facing positions out on our work crews, serving in management positions, leadership positions like myself. And so we're very, you know, lucky that we work for an organization that actually does, you know, believe that folks with lived experience can actually, you know, be a contributing member of our organization. You know, we provide immediate employment to the folks that are coming in. So CEO works as a employer and as a service provider. So the time that they're, you know, enrolled in CEO, they're actually learning these types of skills that, you know, many of our employers, our partnerships and employers have said, you know, looking for people that basically can show up on time, that have a positive attitude, that, you know, bring a strong work ethic, that can contribute to a team. And those are all the things that we teach as part of our transitional work model. And you know, the individuals that are coming through the program are constantly, provided one-on-one coaching on, job sites, building that team cohesion, learning to take positive, or feedback, constructive feedback from a supervisor. And so by the time that we, place that person or work with that employer to get that person into a job, we really do know that it's a good fit. We've actually, worked with this individual for, almost 6 months of them being employed. And the interesting thing is when employers call, when I do get a reference check, no one ever calls and says, "Oh, did you know that, Rob had a criminal background?" That's never been a question that's ever come up in any conversation I've had with a hiring employer. It's always been, what type of attitude did this person, display at work? How did they, work on their assignments? Could they work independently, to work as a team? So, it's really, from where I sit, very inspiring to see so many employers that are looking beyond that. And absolutely, there's gaps around, the employers that we do send folks out that go on job interviews and, come to find out that they didn't get the job based on potentially their background. But it's really encouraging to see many employers looking past that. But I think one of those things that works is the relationship, that constant building of those bridges with those employers, that, even though they know that there's rules and regulations that they have to follow, the word of mouth and trust that comes from, a solid reference, and a warm handoff has proven to be hugely successful. And we have a relatively high percentage rate. Pre-COVID, we were placing about 60% of our folks in jobs. And then as part of our program, following it for 12 months, 50% of those folks are staying in jobs. So, we see that, definitely we have a model that we believe is extremely, at least from, our region, effective. Nationally, like I said, we can't ever talk about CEO without saying, what we do in terms of the big picture. I think currently the CEO is the largest transitional employment program in the country, or focused solely on formerly incarcerated individuals. So this is our, program model, a nice visual, the amount of folks that we serve every year. And, this goal of 4,000 jobs, full-time job placements, really does, I think, speak to the one-to-one relationship that many of our offices and our job developers, and then our reputation as, and that reference, and the employers, that trust that we've been able to establish with, in San Diego, we have well over 800 employers that we've worked with since our startup in 2011 here. These are definitely numbers that we're pretty proud of. And, one of the things that we also believe that's working is, when we have these conversations with employers, we're very transparent about who we are, the folks that we serve, and the data, because we do get those questions about, is this person, could they go back to jail? What's the recidivism rate? I mean, that word gets thrown around like crazy now. Even employers are asking these kinds of questions. So, having solid research and data on the program model has proven very effective for these conversations. And it's very interesting to see that employers are willing to have these kinds of conversations, and that you have something very substantial to back this up. And being able to sit down with an employer that's read, our research, and then ask these types of insightful questions has been really encouraging. And I've had a number of conversations with local employers around this. this data point. So that's to my surprise, they were extremely interested, and some of them actually have become a little more engaged in terms of our, support system, donating to various toy drives that we have, or, really wanting to support the longer term success, not even for folks that are hiring, but just to make sure that, we are in the community and that we're here, serving folks. Another big thing that people really enjoy seeing, at least in my experience, is how does this, what's the return on investment? These are conversations that we're able to have with local policymakers, elected officials, because, we do need their support to fund programs like this. And, obviously, if they can show that investment in this, population actually is an investment in the community, that seems to be very effective as well. And having a policy person, for us, Greg Cox is a local county supervisor. This is some numbers that he is very interested in, but, Greg Cox also sits on a number of economic development councils and provides, connections that way to, an EdCo company. They are interested in hiring people based on the fact that he referred us there as a best practice to look at. What we think is working definitely is having these sort of numbers as well, not just the recidivism numbers, but also these return on investment numbers for those folks.
Robert, that's a great point. And unfortunately, we're out of time. Are there some concluding remarks? And perhaps people will have some questions after our final speaker as well.
Yeah, I think, it seems like we're preaching sort of to the choir in terms of the panel here, but, I think the closing remarks that I would have is that, all of these things that we hear here today is a collective of the efforts, and that, being a part of any one of those things is absolutely helping. So, if you're interested in these kind of big picture things, like, Father Greg said, and, at that very high level, or even on the ground, there are definite ways that make an impact on the people in these programs. And I'll stop sharing my screen now to give you back I can get out of this thing.
Well, thank you so much, Robert, and appreciate your remarks, and I wish we had more time. But our final speaker for today is Jonathan Yackley, and it's my pleasure to introduce him. He's the Deputy Executive Director at Rise Up Industries in San Diego County. Rise Up Industries enrolls formerly incarcerated, previously gang-involved individuals into their 18-month full-time reentry program, which includes full-time paid employment, job training, and other wraparound services. In this role, Mr. Yackley has had the opportunity to spend countless hours with the formerly incarcerated, hear about obstacles they face, and be positively impacted by their courage to pursue positive life choices in spite of those obstacles. So I'll turn it over to you, Jonathan. Thanks for being here.
Yeah, thanks so much for the introduction. As mentioned, my name is Jonathan Yackley, Deputy Executive Director at Rise Up Industries. We're modeled after Homeboy Industries in LA, and Father Greg Boyle, who spoke earlier today, had actually encouraged our founding a number of years ago in order to help fill that gap in reentry services in San Diego County, especially reentry among the formerly incarcerated, or among the formerly gang involved, which is a subset of formerly incarcerated that we work with. Everyone in our program goes through this 18-month full-time program, and they all grew up in street gangs. So kind of representing a systemic issue that underlines a lot of the formerly mass incarceration and other issues involving the formerly incarcerated. So in this role, I've had the pleasure of getting to spend most of my days, most of my hours, most of my social interactions with people who have records for the most part, violent records, and getting to hear about the obstacles that they face. Now, we as a program have not had any trouble placing our graduates in jobs. All of our graduates have gained immediate employment upon graduation, and pre-COVID, all 100% of our graduates had also retained employment at a livable wage. None had returned to incarceration. Part of the reason for that is that we are placing them in an industry that is very high demand and very low supply. The advanced machining industry in California that stopped training advanced machinists and machine operators with the baby boomer generation. So, but it's important to note that part of the reason we've had so much success in that area is that, for one, we're putting our name behind them. So it's not just a formerly incarcerated person applying by themselves, as would be the case for most formerly incarcerated persons, but they're actually getting a recommendation having gone through a pretty intensive program. And then two, we're placing them with local manufacturers. And this is a huge issue in that local manufacturers will hire you and it'll be a good job, but the big players, the national and the international manufacturers, the aerospace companies, these are the ones that, as long as they continue to be restrictive among the formerly incarcerated and completely unnecessarily restrictive, I might add, this is still going to be the biggest barrier that the formerly incarcerated face. Now, one of these individuals that I have got to spend a little bit of time with is Mr. Manuel Rodriguez. He offered for me to share his story and his name. So if you plan on publishing this to YouTube or wherever, you can feel free to use it. He's super exemplary of what the formerly incarcerated face, especially even when they have a technical skill and they're actually in high demand, and yet the discrimination that they face in the job force is still very real. Mr. Rodriguez was convicted of a violent crime as a teenager. He did 30 years in prison. During that time, he learned how to become an advanced machinist in computer numeric control machining. And his skills and experience were such that when he finally left incarceration, he posted them to a job posting, and he had 4 to 5 big aerospace companies invite him over to a job interview right away. They wanted him and his skill set so bad because that's so needed in the industry. And so they invite him out, and I don't even have to tell you guys what happens. They look at his resume, and ban the box or not, his resume is a box that's checked. Employed at state prison, employed, no references because you're not allowed to call COs or staffing staff companies that are while you were incarcerated that can actually give a recommendation for you, because you're not allowed to have contact with them after your release. So his job references, whether there's a box or not, his resume says he was incarcerated for a number of years. And so he didn't get any of those jobs. So he started to use a workaround that a lot of the formerly incarcerated use, and that's staffing agencies. So staffing agencies are going to get you placed with an employer based on their recommendation. And so the employer gets to work with you for a few months so that when the contract ends with the staffing agency, you can continue on. Hopefully the employer likes you and you can continue on working with them. So the first 4 staffing agencies he worked with very explicitly in both written and verbal interviews asked him about his felony, if he had any felonies, and asked him to give detailed information about those felonies. None of them called him back. The 5th staffing agency he reached out to, they asked him these questions, but by this time he had gotten good at what he called playing the game. Instead of saying I was employed at this prison, I was employed at the state of California. Instead of writing out, his specific felonies, he just would write his penal code so that if they weren't aware of what that meant, maybe he would slip through the cracks. And he didn't talk about playing the game in some triumphant tone. It was really a lamenting tone because he did not want to play the game. The only reason he was able to prove to the parole and probation board that he was fit for release was by being so squeaky clean and integrous about every aspect of his life that they could not find fault in what he was saying. And it's honestly a level of integrity that we as a society would do well to be enforced on all of us. None of this dancing around issues, just very specifically saying exactly what his life was about. And so for him, having to play a game where what he's saying on a resume is technically true, but frankly feels disingenuous, is not something we should be putting on anyone, let alone formerly incarcerated, who are struggling to really reintegrate into life and to make positive life choices. So he plays this game anyways, despite what he wants to do. And the fifth agency, he's still not that great at it, so they still kind of found out. And so even though they got him some interviews, none of them worked out because of background concerns, they would tell him. Finally, the sixth staffing agency, he slipped through the cracks, and they placed him with an aerospace company. And it's a great job. It's the job he always wanted. And yet he's here interviewing for a job at Rise Up Industries at the same time. And we got to ask, well, so you got this job, why are you interviewing here? And he's like, well, in 3 months, this company, the staffing agency contract's going to run out. And this company is going to ask, they're going to look at my record. They're going to look at my resume. If they run a background check that runs more than 7 years, I'm in trouble. If they just look at my resume and try to call up, see that I don't have references, I'm in trouble. And so I need a plan B. And there's something deeply wrong with this situation where someone who is more technically sound than possibly anyone on this call within their own profession, more technically sound in his profession, in a profession that's so highly sought after, still struggling to get employment. And so I think my main two recommendations, they're practical, they're functional. I don't know whether they would fall under the legislative or regulation senses that would go beyond my area of expertise. But the two really practical suggestions I have to enhance the impact and the affective intent of the Fair Chance Act would be, one, if you're going to employ someone in incarceration and benefit from their effort and work, they don't have to, they're choosing to, and you're only paying them $1 a day anyways. So there are 13th Amendment rights already being taken from them. So if we're going to go through that process, at the very least, one, you should give them a DBA that they can put on a resume, a doing business as. It's simple. It's not complicated. Every prison could do it in a day. It would be so simple for them. They could, with full integrity, say, I worked at the machine shop of Donovan. Very simple. Two, and again, if you're going to be employing someone and gaining so much from them with hardly giving anything back, you got to give a reference. Now, I understand that there's laws that you can't communicate with certain people during your time of incarceration, but there's no reason why a supervisor or a correctional officer cannot give a recommendation of your job to a third-party HR broker who is a number that you can call and get a reference. And when an employer calls up that number, an HR rep answers the phone and says, looks up your name, okay, Manuel Rodriguez, got it. I can confirm that Manuel Rodriguez worked at this job for these hours, and this is what his supervisor would like to be said about you. So those are my two main practical recommendations. They're based off of my experience with the formerly incarcerated, and I believe that they're representative of what a lot of the formerly incarcerated nowadays would like to have communicated. Thank you.
Thank you, Jonathan. There's a lot of food for thought, and I'm particularly interested to hear more, perhaps in another venue, given the timing issues, about the reference issue with respect to employment in prison. So it's 3 o'clock, which is when we plan to adjourn. I do, however, want to make sure there's at least some time available for public comment and council member comments. I think let's reverse the order of those two and start with public comment. So if there's any members of the public that want to provide any concluding comments before we adjourn, again, you can utilize the raise hand function or the chat function within Zoom, or send an email, and I'll turn it over to Deputy Director Romero to facilitate that.
Let me just add also that we have Fabian Garcia from Homeboy Industries to answer any questions also.
Thank you.
There are no raised hands, but we do have one comment in the chat box to read. The DFEH sample forms indicate that employers should consider the age of the conditional offeree at the time of the offense. This suggests that a young offender with a youthful indiscretion could get more leniency than an older offender who presumably should have matured and known better, which arguably raises age discrimination concerns. Did I hear correctly that it is permissible to consider protected class information in the fair chance individualized assessment and reassessment, whereas it would be impermissible to consider such information in hiring decisions under the Fair Employment and Housing Act? And that's from Alexander Markolov.
The question is about our form that we provide to employers. So thank you to Mr. Markolov for flagging this. Certainly, the statutes and regulations treat juvenile offenders differently, including by prohibiting inquiries into criminal history that was processed through the juvenile justice system. Our form, as I look back on it, is broader than that. So let's take a look at it and see whether we are inadvertently encouraging people to treat applicants differently based on age in a way that wouldn't be appropriate, as opposed to appropriately recognizing that youthful offenders, as we heard earlier from some of the researchers, people are more inclined to commit criminal offenses when they're young. That doesn't mean that they're going to continue to commit criminal offenses throughout their adult lives. So let me take a look at those forms and we'll see if there's something that should be changed.
And we have one other comment in the chat box to read, and this may be a case specific and may not be able to discuss it now, but I'll read it anyway. From Community Legal Services in East Palo Alto. Hello, I have a question about when the conditional job offer is considered to be made. I have a client who interviewed and gave his consent to run a background check. He was not offered a job and led to believe he was hired pending a background check. When he filed with DFEH, the representative informed us that consent and/or authorization to a background check constitutes a conditional job offer. I'm concerned about this, quote, loophole, end quote, because it, one, violates the spirit and intention of the law, and two, it is an impact on people of color and workers with criminal records. I request that the council clarify that obtaining a worker's consent and/or authorization to run a background check does not constitute a conditional job offer.
Thank you for those.
Can I comment on that just for a minute? I think what would be the question when we were considering the regulations came up about whether there should be a definition of a conditional offer, job offer, and I'm wondering if this person from the Community Legal Services might be interested in suggesting maybe how that could be defined, as well as others, in terms of what the council might consider if we ever do amend the regulations.
I want to agree, but before I do, Judge Ortiz, did you want to say something?
Well, I was just going to say I would want to be very careful about that. In California, you know, I guess I'd be careful about limiting what constitutes an employment contract, as it might impact other areas of the law as to whether someone was actually employed or not. You know, I do understand we want to be clear about what constitutes a job offer, a conditional job offer in this context, but I'd hate for us to set some kind of limitation on what constitutes a job offer and then have another area of the law argue that certain employment protections didn't apply because there wasn't a true job offer under our limited definition if we came up with one, if that makes sense.
It's something I think we'd have to be careful about. We have addressed in the regulations some issues of gaming the system. For example, in the most recent regulations, we took care of a potential loophole whereby people will employ someone temporarily as a means of evading the Fair Chance Act entirely by saying, look, we hired them, we didn't check their background, we don't have to do due process. And then, you know, week 3 of their employment, they do that and just fire them. And and think that they're outside the ambit of Fair Chance Act. So certainly there are opportunities to address some gaming of the system, but council member and soon to be judges Ortiz's concerns about unintended consequences, of course, would be something we'd have to be mindful of.
And one way to approach it, I think, is what this person may be suggesting is what does not constitute a job offer. I mean, you may be able to spell it out that way, give some guidance, not necessarily spell it out. That's not, but to give some guidance as to what isn't a conditional job offer.
Any more public remarks before we turn it over for any council member remarks and conclude our hearing for the day?
I'll note that we have received 3 written comments to the council's email, 2 of which are quite long, and I'll provide all of those to the council members following the hearing. We do have one final raised hand from Terry Curd, and I will unmute Terry now.
My question is, does the council also work with reentry councils throughout the state?
The council so far has not, although that'd be something we'd be interested in learning more about. I don't know if the greater department does.
Okay, thank you.
All right. Any other council member remarks before we conclude?
I just want to say, so I guess I'm commenting in my role as ex officio council member. I want to thank everyone, and especially in this last session, Michelle, Shelly, Jonathan, Rob, and Felicia. Where we sit, we feel very passionately at the state level about this law, but it's also true that we sit here and, as we're sitting here today, we might have 6,000 open cases. And what you have done is bring human voices and experiences to the conversation that I think is really an irreplaceable gift to those of us charged with enforcing the law, to those of us charged with interpreting the law. And I just want to thank you all and the other panelists throughout the day for bringing those voices and those experiences in real time to us. Thank you.
Hear, hear.
Thank you for having me.
Thank you so much. Thank you so much to everyone. I just learned so much today. Thank you.
Thank you for allowing me to be a part of this.
Well, thank you so much, everyone. That wraps up today's hearing. And again, immense gratitude to all who participated. This will be online as a reminder, both on the YouTube of the DFEH and on the website. So the materials like PowerPoints will be there. And we, it's now our task really to absorb this information and to make sure it's translated into action items. And that's certainly something I think we'll intend to do. So thanks again. That wraps up today's hearing. We hope you make plans to join us for our next council meeting on December 4th.
Thank you.